Live. Good morning. This is the New York City Board of Standards and Appeals Public Review Session for June 16th, 10 a.m. session. There'll be no public testimony during the review session. The first item is 2019-74BZ, 11251 Northern Boulevard, Queens.
Okay, our last hearing on this was on January 14. Although we did have an initial hearing notice of hearing for this teleconference with dial-in info that was provided to officials and neighbors. So this hearing was noticed a second time for this particular hearing, or let's say this application was noticed a second time for this hearing. We have one new letter in support. Letters in opposition were submitted prior to the January 14th hearing, and I haven't seen during my review of the recent materials anything subsequent. There are still open violations issued for disregard of the stop work order and dangerous working conditions. I don't know if work continued in the face of the shutdown or just prior to the shutdown. There are approximately $150,000 in penalties due, dating back to 2017 and as recently as November of last year. A 2013 survey was resubmitted. It is in Queens datum and National Geodetic Vertical Datum, known as NGVD at Sandy Hook. That is not North American Vertical Datum, known as NAVD 88, which is the current standard. At the last hearing, I had asked that the surveyor certify the elevations on the survey in NAVD 88, and also to certify the differences between mean sea level and NAVD 88, because the FAA uses sea level as its datum. A surveyor is a licensed expert on the subject of these comparative elevations and is responsible for the veracity of the survey. An architect is not, and relies on the survey for all of its design calculations. There is a false statement in the statement of facts that the 2013 surveyor, the one who prepared the survey in 2013, is no longer in business. Hence, the survey cannot be updated. That's a very curious statement in the first place. But in the second, a quick Google search revealed that company's website, and a quick call by me confirmed that the 2013 survey can indeed be updated to NAVD 88, and that the same surveyor who signed and sealed the drawings would be available to do the work. So I'm, let's just say, surprised by such a statement. The drawings were revised to show elevations in NAVD 88 and to clarify the differences between that datum, Queens datum, and above mean sea level that is used by the FAA. But as I stated above, these rely entirely on assumptions made by the architect and not on the certified survey. So we need the certified survey. And the reason I keep insisting on this is we did have an application where the architect represented some kind of certain differences. And the differences were off by several feet, actually. I think it was as much as 3 feet. So drawing BSA 3, west elevation, indicates that the quote, proposed building height will be 359.81 NAVD 88, or 360 above mean sea level. But the chart on the drawings indicate that the parapets will be something in the range of 14 feet high and just under the maximum FAA allowable heights. So first of all, how are those parapets? But besides that, I'm afraid that it seems to be misrepresenting the height of the building. It's measuring to the roof as opposed to 14 feet higher, which is just under the FAA limit. Also, I see the FAA maximums, but not the zoning resolution analysis under section 61-20. There is one minuscule diagram on BSA 01, but I don't see it going through each of the surfaces required for the analysis. That's what we asked for at the last hearing, was to understand exactly how this building complies or doesn't comply with underlying regulations. Also, the sky exposure plane and the required setbacks are not shown on the elevations, and there are no sections. There are no dimensions indicating the setbacks and rise to run. There are some lines, but it doesn't tell you what they are, and it doesn't show any dimensions. So I don't know how we know this building even complies with the underlying zoning for the underlying district. The proposed tops of lights, of the warning lights, will fall just inches below the maximum FAA heights. The elevation shows that the building will rise to just below the maximum FAA allowable height of 375.81 NAVD 88 and 376 above mean sea level. In response to our questions about the expiration of the FAA approvals, the applicant provided a PowerPoint presentation that breaks down the approval and permit duration extension process. So it just talks about when it was issued and so on. I note that the PowerPoint mixes measurement data. It says 150 feet above the airport, 171 feet mean sea level, 171 feet above mean sea level, which is it? You can't mix all of that on one small document. The PowerPoint states that the site is located within, quote, diverse departure A airspace related to runway 13, but the diagram doesn't show where the parameters of that zone are and shows that the building is outside of the red zone diagram. So I found that very confusing because it didn't give us enough information. Another page in that presentation apparently is intended to show that between 2015 and 2020, there have been no changes to the LaGuardia takeoff minimums for runway 13. I think that's why they gave it to us, but they don't explain. That was one of our questions was, you got an approval so long ago, how do we know that the FAA hasn't changed any of its requirements? Also, the expressway visual runway 31 diagram shows the flight path passing very close to the building after it parallels the Long Island Expressway and overflies Flushing Meadow Park. There's no explanation of the distance between this path and the high point of the building. And I asked, wouldn't this new 40-story building, or almost 40-story building, where the tallest buildings in the immediate area are only 14 stories, require a change in pilot behavior? So now it's the biggest thing everywhere. Wouldn't flight control require that they take a wider berth or something like that in the event, for example, of high winds? So what about during high winds, or flight path changes during the US Open, where I understand they're not allowed to fly over the stadium, or a condition that's called circle to land? What about those situations? Are those taken into account in that study? The videos of the standard flight path that we've received, a video, which is very interesting always, the video of the standard flight path doesn't appear to show the height and location of the proposed building. So we actually don't know where the building is relative to this plane that's coming in or taking off. The applicant states that the board's consideration under section 7303 should be limited to allowing what the FAA allows, provided it is permitted by the underlying zoning. But this is actually a special permit. It's not it's a discretionary approval. And without it, the building is limited by the underlying zoning for construction near airports pursuant to section 61-20. Section 73-03A states that the board should weigh the advantages and disadvantages to the community posed by the proposed project. And as discussed, this is an extremely tall building in a neighborhood where the tallest buildings appear to be only 150 feet high. We had asked that the applicant explore shorter buildings with equivalent floor area and got nothing on that. I'm not understanding why this applicant chooses to ignore neighborhood concerns or board requests for further information. And it's very evident from the submission that this is not a design project. So it could go lots of different ways. I mean, they gave us sort of a sketch of sort of a quick idea of what could be there, but it's clear that they have not pursued the design of this building in detail, or even not detail. The applicant submitted also a 2016 Department of Environmental Conservation Certificate of Completion for Environmental Remediation, and states that is seeking a letter from OER to confirm the compliance status of the site. And then I understand that from our seeker officer, Tracy Benke, that noise analysis and hazardous materials screens that were submitted are acceptable. Therefore, type 2 classification is confirmed. So Tracy, did I get that right? Are we okay with that?
Yes.
Oops, good. Okay, thank you. All right, so then I go to Commissioner Shanda. Yeah, you're muted, so.
Okay. So I'm a little confused by the statement about the heights not being clear, because I kind of use BSA 07 drawing to kind of determine where all the maximum heights of the buildings are proposed in relation to the FAA approved height. So as I understand it, the proposed building height, that is the top of the roof, is at 359.81 NAVD 88. The parapet wall height is to the height of 373.81 NAVD 88. And the light that is mounted on the parapet wall, the height of the highest height of that light, the top of the light, is at 375.31 NAVD 88. And the FAA approved height limit is 375.81 NAVD 88. So I did not see any issues with the proposed project in terms of meeting all the FAA requirement, and all the maximum bulkheads heights and everything has been indicated in this diagram, which is section through roof parapet 1. Maybe the applicant can provide a little bit more clarity and the notation in all the elevation drawings indicating to refer to that to get a clear distinction of the height separation for each one of these elements. So I was quite satisfied with the submission that the applicant provided in terms of, we had asked for clarification on the diagrams, and especially the providing a comprehensive report of the aeronautical study. The FAA consultant has provided letter clarifying that the FAA determination remains valid. That was one of the questions we had asked, that the FAA determination remains valid since the notice of construction since the notice of construction was filed. It was filed in 2018, and once the notice of construction was filed, the expiration date of FAA determination is disregarded, and the applicant provided the DOB approved mean curve elevation analysis. That was another question we had asked, and the revised plan shows the building height from the mean curve elevation and above ground level NAVD 88. The applicant, the only thing that is still outstanding is in my mind, is the clarification with regards to the status of the fines and outstanding whatever work that needed to be done to address some of the fines. I would like to know the status of that. And I think this area was clearly zoned R6 to allow for a as-of-right development. And as long as this development in as-of-right, my concern is primarily around whether it is the bulk form, whether the building bulk height is within the FAA approved height, which again, as I stated, the BSA drawing 07 section through roof parapet shows every element of the building and the light is below the FAA approved height. So I have no other further comments on it.
I just want to clarify that what the lack of clarity had to do with, I had asked for a surveyor to certify that they're right about the difference between above mean sea level and NAVD 88. And that was not done. That they're relying on the architect who used some kind of copy paste from some document. And that means the architect is taking responsibility for the elevations, and they can't. It has to be from a surveyor. That's the first.
Okay.
And the second was that because I know we have a lot of members of the public listening, I wanted to be clear that the height to the roof is very different than the actual proposed final height. There's a 14-foot difference between the top of the parapet and the roof height. So it's not a 359-foot high building, it's a 370 something foot high building, because I don't have the number right in front of me. So I wanted to be clear about that. Okay. And then the other part of it is I had asked for them to show what an as-of-right building is absent the special permit, and they didn't show the sky exposure planes, et cetera. Well, not even absent the special permit. With the special permit, what is the sky exposure plane permit? And we didn't get that information, which is what we asked for. Okay. Okay, go ahead. Commissioner Otley Brown.
Yes, I had the same confusion about what the project is in NAVD 88, because it seems like some of the papers were updated and documents and some weren't. So like if you look on the PowerPoint, everything is in AMSL. So then you have to then refer back to another document where it may have been corrected. I found that pretty confusing and don't understand why everything isn't just quickly do a search and change and sub in the NAVD 88 heights. Then I looked at the two videos and I actually thought the videos were really helpful because it gives you an idea of how low those buildings are below the planes when they're actually taking off and landing. So I found that really helpful. My only question was, is there ever a deviation from the flight path shown in the videos? Because my flying experience leaving LaGuardia, sometimes we take off due south on runway L13, and that does pass a little closer to the building, but it kind of approximates what the approach is. And so if they could just answer that, that's basically my only two questions.
Okay, thank you. Commissioner Sheta.
Thank you, Chair. I just want to start with saying something that's contrary to what the vice chair mentioned. This building is not as of right. And that's why they are here. This building needs a special permit, and that's why they are before us. The second thing, first of all, I've been to the site last Wednesday. I did visit the site, and the reason I did, because I looked at the submission and I couldn't find what I asked for, which is an update on the construction status.
Sorry, say that one more time, an update on the what?
Construction status.
Update on construction status.
Yes, I did ask for this last hearing and I didn't get it.
Mm-hmm.
That's why I decided to just shoot to the site and take a look. And what I found is it's just excavated and there is a perimeter. I'm not sure if this is a foundation wall or it's a retaining wall. It's a concrete wall on the perimeter, I believe. And they excavated, I'm not sure, plus feet below grades around the site. I did shoot a video on site, so I do have it. I can just submit it to the record.
Mm-hmm.
But looking at the drawings, I believe the drawings show clearly the height of the building. I on that. The special permit, again, like the chair mentioned, is a discretionary approval from the board. It doesn't mean that if somebody gets an approval from a sister agency or from even a state agency or a federal agency, it doesn't mean that we're gonna just rubber stamp this. We have to look at it. And I believe the umbrella for approving or denying a special permit is to look at the general requirements of a special permit, under which I believe it's big, bold, italic, very clear that whatever structure is proposed, consistent with the neighborhood character.
Can you repeat it, Commissioner
Sorry,
Shetta?
you keep, Commissioner Sheta, you keep fading in and out, and I think now you're frozen, actually. Can you stay closer to your microphone and say that last part about, whatever, the standards of review?
Okay, am I clear now?
Yes, stay close to your mic.
Sure. The general umbrella for a special permit approval or denial is to make sure that the proposal is consistent with the neighborhood character. In the area around the building, I couldn't see any building even close to the proposal. So as a board, we do have the right, if we believe that this building is out of character, to ask for modification. And that's what we did last hearing. We did ask for schematic for other buildings that extend more horizontally, but less vertically. And I didn't see that in the submission. And in addition, yes, I understand it was a notice of construction to proceed to the FAA, and probably they didn't hear back from FAA objecting to that, but that doesn't mean that the approval is updated. With last hearing, we did ask for an update to the approval, and we didn't get that.
Mhm. Okay, I just want to clarify one thing. The standards of the standard of review under a special permit, the general special permit requirements of 73-03 are the board shall make all of the findings required in the applicable sections of the chapter, so related to the specifics of that special permit, with respect to each special permit bulk regulation, and shall find that under the conditions and safeguards imposed, the hazards or disadvantages to the community at large of such special permit bulk regulation at the particular site are outweighed by the advantages to be derived by the community by the grant of such special permit. In each case, the board shall determine that the adverse effect, if any, on the privacy, quiet, light, and air in the neighborhood of such special permit modification of bulk regulations will be minimized by appropriate conditions governing location of the site, design, and method of operation. So it's a different standard than a variance where it needs to comport with neighborhood character. It's a balancing of the disadvantages and advantages to the community, and in specifically with respect to privacy, quiet, light, and air in the neighborhood. So that's your standard on this one, okay?
Okay.
Anything else you wanted to add?
No, thank you.
Okay, and Commissioner Shabeta.
Thank you, Chair. I want to begin by saying I was surprised to learn that your phone call to the surveyor provided you information that was in direct conflict with that which has been submitted, and it puts into question other assumptions that we may have made to what has been submitted. I share Commissioner Otley Brown's frustration with the lack of uniformity in the submission and having to go back and forth between documents to understand what's going on. And I do second the chair's and Commissioner Nasser's, Commissioner Shetta's request to have this an updated approval. Going to 7304 conditions and safeguards while reading and conjoining with 7366A, I think we have to first consider what's the purpose of the special permit, and what's the safeguard, the original safeguard in mind on the special permit. And that is necessarily for a height restriction for safety of airport purposes. Now, once after that, I think we have the question of whether or not what adverse effects have we learned of? And the adverse effects we received from the testimony was light and air, but to some extent, I had the feeling that there is nothing that could be built here that wouldn't have had an adverse effect on some people who are testifying. If I recall correctly, there was one lady on the first floor who was complaining that her light and air on the first floor of a parallel or a building that was complaining that she wouldn't have appropriate light and air. I don't necessarily believe that's something. There's any building here that would satisfy that concern. So while I agree with some of the concerns with regard to the adverse effect this building may have on the community, I think it needs to be in a balancing test. There is a right to build here. They are following the regulations that they would have to follow. I'm not going to opine on whether or not we have the authority to regulate as of right uses. But I do think that we should be cautious when regulating it on adverse effects, that if this building were 2 stories lower, those adverse effects would still be something complained of.
Yeah.
That's all I have to add to this.
Thank you, that's helpful, yeah.
I just want to bring a technical thing is I'm not able to use the button for raising hands. It's not, so.
Oh, really? Okay.
Yeah, not sure why. Every time I press it, it gives me the recording button.
Oh,
So
maybe the hand.
I don't know if others are having that difficulty.
Okay. No, I see Jella's hand is up and Daryl's hand is up, but okay, go ahead. Maybe
I just wanted to clarify when I said this building is as of right, absence of it being in the flight path, the bulk form that is being requested is an as of right. That's really what I was getting at, being an as of right. It meets all the R6 requirements, absence of the flight path thing.
And I think that's something that they were very clear in their submission of, and they stated on the first date.
Yeah.
The only reason we have this case is before us is because of the flight plan.
right.
Now, a lot of I certainly feel the community's concerned. This building has this lot has a very long history, but many of the concerns they complained about are not before us. And while if they chose to appeal based on these concerns, that'd be a very different situation.
Right, okay. I'm curious just about the statement that it's clear that it complies with the R6. That's specifically what I asked for, and I didn't find in the drawings a clear zoning analysis in this last submission, a clear zoning analysis that says on the drawings, not in the statement of facts, because that's not where it belongs, right? It belongs on the drawings. I didn't see if this is an alternate setback building, the dimension that says setback 15 feet, alternate setback regulation section, da, 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 da. I didn't see height following the setback of X to a point, and then you begin your lean of rise to run of X. I don't see that on the drawings. That's what I'm talking about. Show me actually on the drawing that it complies with the R6. I know in the statement of facts, they went through an elaborate discussion of what the rules are, but that's because they noticed, I think, that it's not on the drawings. So it needs to be on the drawings. Otherwise you can't test the claim, right? So I know it's an enormous site, right? So the chances that the building penetrates any of this are Even if it penetrates it with this shape, it wouldn't penetrate it with another shape. You just, because this is a schematic at a very, very early stage. I think, you know, they just kind of drew an envelope and threw some stuff in with some funny windows and make it look like a, you know, 60s modernist interpretation, and there you go. So yeah. All right. Any other comments? I saw hands up before. I don't know if those hands were just to test it. No? Okay. Any other comments from commissioners? All right, so we can move on to the next one.
Next item is 2019-165BZ, 1375 East 26th Street, Brooklyn. This is a review session, no public testimony.
Right, and there are people in the waiting room, and I am assuming they were calling in to testify on Northern Boulevard. You will have your chance to talk, but we're still in a review session, which is essentially the same as an executive session, and the public cannot speak during those executive sessions. So, all right. Okay, plans were revised as requested to lower the height of the extension into the rear yard at the second floor. So I'm okay with this one now. Commissioner Shanda?
Yes, that was a question I had asked at the last hearing, and I am satisfied with the revised
Right.
plan.
Okay, good. Commissioner Otley Brown?
I have no questions.
Okay, Commissioner Sheta?
The drawings that, first of all, I'm okay with the application as is, but on drawing the elevation view, this is the left side elevation. I believe the word existing and new are reversed. I'm not sure if I am correct on this or not, but that's my understanding. Can you check that very quickly? And if they are reversed, they just modify this. And if they can rename the elevations instead of right and left, because these terminologies are relative, if they can make them north and south, something that's related to directions rather than the way somebody might be standing and looking, that would be much better.
Yes. Okay, good. Thank you.
But again, this is, I'm talking about A-10.
It's drawing on elevation A10.
Yes, A10, if you look at the elevation.
Okay.
You see where it says adjacent existing building, and then to the left of that, new existing, is that right? Is that right?
Yeah, I don't know. So we'll get them to we'll get them to check that.
Okay.
Okay, thank you.
Okay.
And Commissioner Shabeta.
I have nothing to add to this application. I'm satisfied with the application.
Next one, Tony.
2019-269BZ, 3425 Rumbots Avenue, the Bronx. It's a review session.
All right. Plans were provided that are supposed to have shown a guardrail around the pole. The guardrail is not shown on the site plan at all, and no information about its height or materials is provided on any of the drawings. Also, it doesn't go all the way around the pole. It's only halfway around. I don't understand that. We had asked for a DOB sign-off letter stating that the pole height is an existing non-compliant condition as to height, since this board has no authority to waive the zoning resolution bulk requirements under the special permit. We didn't receive that. We did reach out to DOB's sign enforcement unit and learned many things. We learned that the purpose, and Deputy Counsel Vine, feel free to correct me if I've made errors on this. We did reach out to DOB's sign enforcement unit and learned that the purpose of the consent agreement in 2006 between this sign company and DOB was to toll DOB's enforcement action against the listed illegal signs unless they were, or unless until they were legalized or removed. So it gave a tolling permit to go and get permission to maintain them or remove them. The benchmarks were provided to determine when DOB would enforce. Not that if you hit the benchmarks, then it's legalized. That's not what they were for. It was if you hit the benchmarks, DOB won't enforce until you have no longer, until the benchmarks have passed and you haven't corrected. So roundabouts, turns out, is an illegal sign and sign pole. DOB didn't tell the property owners how to solve the problem with the illegality. Only that observing that they only observed that there were options available for conversion of this pole to support an accessory business sign, a not-for-profit sign, or telecommunication equipment poles. Those were the sort of obvious ways of curing the illegality. None of the sites listed on the agreement are legal. Roundabouts, therefore, we're instructed by DOB, should be viewed as a vacant site, and there are no vested rights as to the pole's height accrued since it was erected as illegal advertising signage. So in short, to proceed with the application, the pole height, if it does not comply, has to be reduced to comply with height and setback regulations of the underlying district. We discussed this at the very first hearing, that the pole must comply with section 4343 height and setback, sky exposure plane of 1-to-1 above a height of 30 feet, which is set back 20 feet from the street line. And we had asked for that zoning diagram and never got it because the applicant insisted that they were somehow or other vested under this consent agreement, which we understand from DOB was not the case at all. A revised radio frequency exposure level report was provided, and while much more detailed than the previous one, I'm curious why, for example, on vertical simulation 1, there are no dimensions on the grids to indicate the heights and lengths of the different exposure levels. I don't understand who prepares these drawings. They're kind of prepared like they're speaking to themselves and they already know the answers. They're not creating these for others to read. So there's a exposure grid with no dimensions on them. And then on the adjacent building simulations, the preferred graphic description method is to show nothing as opposed to a color scale indicating a range of radio frequency at the studied level. So basically it's just this white page and they're saying they studied it. What I read that is you studied everything that's on the white page and discover all of it is 0. Well, you couldn't have studied everything on the right page because you just wouldn't have. There should have been, we talked about this at the last hearing, it should be a tone that you can see, and that within that tone it's 0, and outside of that tone it wasn't studied. I just find this so confusing. And by the way, the key that's on that drawing says that each grid line represents 10 feet for approximately, when I count the grid lines, approximately a distance of 50 to 60 feet, while the dimensions stated on the drawings are 85 and 95 feet. So is that grid meaningless? And if it's meaningless, then why are the dimensions for that grid shown? I don't understand this. And we commented on all of this the last time. And those are my comments. So Commissioner Shanda?
Well, in terms of the analysis, I did not have any additional question. I did wanted more clarity on the plan with regards to the guardrail and as to why the guardrail was not covering the entire base of the pole. Of course, the issue with regards to DOB's tolling of these signposts is news, and how that affects this project and the height, the applicant will have to clarify that.
And Commissioner Otley Brown?
I agree with you on the lack of clarity on the plans as to where the guardrail is. And when you go on the site visit, the pole is only set back about 20 feet from that lot line. And so it probably does extend through the sky exposure plane. So I don't know how to resolve that other than to put something into our resolution that would say that we are not in any way allowing a violation of any of the zoning regulations regarding height setback.
Mhm. That's one way, and yeah, I see what you're saying. So the only thing, yeah, that one's tricky. So on the one hand, we'd allow it to be telecommunications equipment. On the other, it's up to DOB to look at whether it complies with zoning because we're not waiving any bulk requirements. Right.
Right.
I see. Okay, thank you. Commissioner Sheta? Unmute yourself, please.
I did. I was making sure that I'm unmuted.
Okay.
Thank you. I have two things. Number one, regarding the RF study. I believe it is clear, and their conclusion is that there is no exceedance at the locations of the adjacent buildings. I just want to make sure that they considered exist and the tallest and the closest possible building, their zoning regulations that prevails in the district right now. So probably you have an adjacent 2-story building, but the zoning allows for 4-story building. Did you consider that? If not, please take a look at it. If you did, we need a statement in the study that says that we considered the closest existing and possible proposed building around the proposed antenna or telecommunication structure. The second, the high exposure, I believe with simple math, you could conclude that that tower or post or pole or whatever, it does penetrate because the distance between the lot line and the location, if it's 20 feet and you go up 30 feet at the property line or the lot line, and then you go 1-on-1, for each horizontal foot, you gain 1 vertical. That's what 1-on-1 means. So 30 plus 20, I believe the proposal is much more than that. And I believe that's why they didn't do what we asked last hearing. So
Yes.
here we go.
Yes, I agree. Yeah. Okay. And Commissioner Shabeta, thank you.
Thank you, Chair. I agree with what you stated and what has been stated by the other commissioners. My concern with approving this and stating that we're not waiving sky exposure plane, I think that I'm not very sure if that's going to mean something to DOB before them approving it. I have a concern about, and obviously there are times that we're placed in a situation where we have to do it, but I have concerns with setting an approval for something that we can deduct is in violation. And other than that, I have nothing further. Besides, perhaps in the future, we should ask for more specific ranges in the RF study, because it seemed like a really broad range from like 0 to 100, even though that's not, they would have the minimal effects. It would be nice to know if we can have a little tighter of a range in between each jump in frequency.
Okay, thank you. Any other comments from anybody? Oh,
Commissioner Sheta had his hand up.
Yep.
Yeah, I just wanted to mention that I support what Commissioner Shabbat. For me, if we let this go with knowing that most likely it is penetrating the sky exposure, meaning that it's not obeying the zoning regulations in the district, that this is equivalent to somebody's coming to us asking for a special permit for a PCE, let's say, and the entire floor of PCE exists is not legal. So we cannot say, yes, go ahead, you satisfy the requirements or the findings, but DOB make sure that this guy, you bring him to legality. I can look at it like that.
Okay,
So if they are like, if they are not successful to prove it to us that this pool is legal, I would say we shouldn't let this go.
okay, thank you, thank you. And that we have done that in rare circumstances where we can't, where it sort of doesn't go to our approval, you know, where it's kind of another thing. Like we often get them with the 73-622s where we don't know whether the front yard is legal, but we're not approving anything in the front yard. And so we just say, DOB, you have to check out whether the front yard is legal, things like that. So, okay. All right, thank you, everyone.
Okay, so that concludes the public review session for June 16th, 10 a.m. session. We will now commence with the public hearing. The first item is 2019-74BZ 11251 Northern Boulevard, Queens.
Okay, so we have 5 people in the waiting room. I don't know if they're all calling about the Northern Boulevard case, but I'm going to admit them and let's find out. And we'll have to have them one at a time. Okay. When connected. Okay. For the people who have just joined us on Zoom, please turn off your YouTube videos. And I'm going to, and when you can hear me, please turn off your YouTube videos, everyone. Okay. I still hear someone's YouTube video on. We can't have the YouTube video on because we get feedback.
I'm not sure that's a YouTube video. It sounds like they are.
YouTube.
It sounds like
YouTube usually is delayed, but this one is kind of an echo.
it seems like they have 2 devices on.
2 devices on. If you've called with 2 different devices, you have to shut one device down. Or at least turn off the speaker on one device. Okay, it's sounding better. Okay, good, thank you. So what I'm going to do is a number of people have called in. Thank you for calling in. I'm going to, some of you are identified only by a phone number. So I'm going to ask that the person whose phone number starts with 718, last digits 468, identify yourself. (718-468). Identify yourself, please. Can you hear?
Oh,
And if you can hear me, please identify yourself. Last 4 digits, 468 of your phone number.
that would be me.
What's your name, please?
Margaret Dozier, Community Board 3.
Okay, can you spell your last name, please?
D-O-Z like zebra, I-E-R.
I-E-R, CB, and you're calling representing CB3?
No, well, I'm a member of CB3. I received an email.
Okay.
and-
Okay, just a second. So you're not calling representing CB3, you're calling representing yourself, correct?
Right.
Okay, all right, so I'm going to allow you to, I'm going to rename you so everyone knows your name. And you have 3, are you calling to testify on the 112-51 Northern Boulevard?
No, I was just calling to listen.
Oh, you're just calling to listen. Okay, so you don't have any testimony. Okay, so continue.
No.
Okay.
Okay.
All right, so then the next phone number I see is first digits 347 and the last digits are 243. If that's you, please identify yourself. Last digits 243. If you can hear me, please speak. Last digits of your phone number, 243. Okay, I'm going to move on to the next person. So for the people who just called to listen in, you could actually be just watching us on our YouTube video. You should be calling in if you want to testify, okay? So I'm looking here, I see Mr. Pittman, whose face is actually on Zoom with us. Would you like to testify?
Yes, ma'am.
Okay, all right then. So you have 3 minutes to speak. So go ahead, Tony, your time.
Okay.
Yes, go ahead. Please state your name and do we give address, Madam Chair?
No,
Yeah.
no address.
My name is Clyde
Okay.
Pittman, and my address for my business is Federal Airways and Airspace at 1423 South Patrick Drive in Satellite Beach, Florida, 32937.
Okay, so but you're actually with the applicant, right?
Yes, ma'am.
Okay, so where's the lawyer who's representing the applicant right now?
May I speak?
Yeah.
So I emailed him, he says, yeah, it's 10 a.m. I think he's having problems. He said, can she let me in?
Oh, so who is it?
Eugene Travers.
Yeah, I don't see him.
Yeah, the number I have is 516 or 212, but I don't understand. I'm just telling him call in again.
There's Daryl.
He
Daryl.
said no one in the project team can get in, he said.
He has a 516 number.
Oh,
Yeah, but he said the office number, the 212 number, I don't want to say it on air. You can
I
call him,
don't
guess,
see
in
anyone in the waiting room, so ask them to call in again.
He said no one can get in. I'll tell him to call again.
I only see a 347 and I called that one out. 347, last digits 243. I don't know who that is, but they're already in. And I see, if anyone is on the project team who is already admitted into the Zoom, please identify yourself. For instance, we have
Ruth Chowdhury? I don't know who that is.
Is anyone else besides Mr. Pittman from the project here? We have a 718 who we just let in. Okay, the person with phone number, last 3 digits 901, please identify yourself.
This is Ed Wesley. I'm president of the Jackson Heights Beautification Group,
Okay.
and I'm also Community Board 3 member.
Okay, so we're hearing the testimony first from the applicant, and we're trying to identify who the applicant is, and we're not finding them. So please hold on, okay?
Okay, thank you.
I don't know what's going on. I don't see. Wait, Brett McCabe, is that somebody from our group? From the applicant?
Unfortunately,
Yes.
I don't know.
Yes, okay. That is, okay. Mr. McCabe, when you can hear us, please identify yourself and who you're affiliated with.
My name is Brett McCabe, and I am the project executive for the project. There is some problem logging in. It appears that the meeting ID and password given on the agenda may actually be different than what gets you in.
Oh, God.
Eugene should be coming in now.
Here we
I
go.
sent him an invite.
Yeah, he's here.
Okay.
So Eugene will need to list who should be here because I can't control his own.
Gene Travers is here.
Okay, so please identify yourself and who should be on your project team participating.
Hi, so this is Eugene Travers, Kramer 11 for the applicant. We also have Clyde Pittman.
Yes.
He's our FAA consultant. Brett McCabe is a project executive. She Verfenstein may be calling in, and Richard Z may be calling in. A couple of us are having trouble when we click the link in the agenda, the Zoom video link. A window, it says open Zoom, and it begins, and it says the meeting is scheduled for 6/15/2020, start 10 a.m., June 15th, 2020 review session and public hearing.
Now, the agenda says June, I'm sorry, may I speak, Madam Chair?
No, just leave it alone. We don't have to talk about it.
Okay.
So I'm sorry, say the name of the other person, Richard who?
Richard Z is calling in. A couple of us are having trouble when we click the link in the agenda, the Zoom video link. A window, it says open Zoom and it begins and it says the meeting is scheduled for 6/15/2020.
Uh-oh. Someone's YouTube video is on. You have to turn off your YouTube video.
Agenda says June, I'm sorry. May I
Turn
speak?
off your YouTube videos, everyone. Everyone. Okay. All right, so Mr. Travers, why don't you start?
Okay, so we'll do this over the phone as opposed to.
And so, sorry, yeah, okay.
We need to swear in the
Swear in.
Yeah, okay, go ahead, Tony.
Okay, so for the members of the team, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes, I do.
Okay,
Yes.
I do.
Okay, and Mr. Travers.
okay.
Okay, so is it just me and Clyde that are connected right now?
I'm also connected, Gene.
Brett McCabe.
Brett McCabe's in. Great. Okay. Sorry for the confusion. So Eugene Travers, Kramer Levin for the applicant. We just listened to the board's review session, so I'll just run through some of the comments. With respect to the survey, first and foremost, I hope the board knows that Kramer Levin is not in the business of misrepresentation. As I understand it, what the surveyor, the company had been sold and the survey data was no longer available. I personally did not speak to the surveyor chair, Perlmutter, but you know, we can follow up on that. I guess the point I was trying to convey in the written materials is what was requested by the board, and the sample that from the prior application that was provided to us is simply, it was really a copy and paste of an image that you can pull from Google. And we can attempt to have a surveyor prepare that if it's helpful to the board. But the fact of the matter is the building that's constructed is not going to be higher than the FAA height limit.
Okay, so let's stop right there, okay? This is a very, very huge, very expensive project. Department of Buildings will not let you proceed without a survey that's updated in NAVD 88. So the idea of not doing it the proper way is super surprising to me. And by the way, you had the architect sign and seal a document that the architect cannot certify to. So it's a classic case of architects being willing to put themselves out there in ways that they really shouldn't. Only a surveyor has the authority to certify to heights and datum and so on. So it has to be a licensed surveyor, and you should be updating this survey, and there's no excuse for it. And sorry, I talked to them on the telephone. I didn't talk about the specific site, but I said it was a survey prepared in that year. Can you update it for me? And they said yes. So if there's other issues about it, fix those other issues.
Okay, we can look into that for the board. With respect to the drawings, I was a little confused about the comments about the lack of clarity with respect to NAVD 88 going back and forth between the statement of facts and findings and the drawings. I was very careful after the last hearing to go through those materials and make sure every height is listed in both above mean sea level and NAVD 88. The drawings very clearly indicate those differences. Commissioner Otley Brown, to your comment, the presentation that Mr. Pittman will be making and the PowerPoint may not have NAVD 88, but we can certainly update that to make it consistent. But if there's any further clarification that we can provide to the board, we will certainly do it. But I thought the materials were consistent between themselves with respect to referencing the different elevations. With respect to demonstrating compliance with the R6 regulations on the drawings, I believe there is a sky exposure plane line. It's unfortunately not labeled. and we can label that.
I don't want to, is the architect on this call?
I don't know if she's connected.
Who's
Yes.
the
Hello.
architect? Hi,
There she is.
who's speaking?
Yeah, this is a Shiva Feinstein architect certified drawings.
Shiva Ferfenstein, is that who?
Yes.
Yes, okay, I see you. Okay. All right, so I'd like to speak to you because I don't want to hear excuses about what it is. So the drawings have to clearly show the this is an R6, right? The
Yeah.
R6 zoning bulk regulations, just like you would be doing set of drawings for the Department of Buildings, where you show the setback requirement on the drawings, what section in the zoning resolution requires the setback, what the sky exposure plane is, actually what it is. Is it 1-to-1? Is it 5-to-7? What is it? And show on the drawings what section in the zoning resolution tells you it's that sky exposure plane, and show the dimensions on it, and then show the sky exposure plane, the height, the setback, the sky exposure plane. So we see the envelope. We see that the envelope complies with the regulations, and then that the building as proposed falls within the envelope. Okay?
Yes, ma'am. We do have on the second page, the BSA-02. That's where we put the alternate required from setback chart. So
Do you have it on the drawings? You don't show on the drawing itself.
yes, the
Where or not
ratio
the building penetrates, right? We
right.
can't, right? That's what we're looking for. Okay.
Yeah, on the elevation, we didn't show the slope, the 1-to-7.6 ratio. Yeah, that we can add it on. So
And
we
also
did
the setback, you're showing on the drawing, the setback from the property line to the
Yeah.
building wall, and what's required under the zoning, and that you're complying with that requirement, and the maximum height before you begin the sky exposure plane. What is that, and how you're complying on the drawing?
Yes.
Okay.
It's all drawn, but not showing the dimension.
Correct.
Apologies for that, yeah.
Okay. All right. Okay, Mr. Travers, you want to continue?
Yes, I'm connected via Zoom now. Hi, everyone. The board's request for a smaller building, I apologize if that didn't come through at the last hearing. We can prepare something. I don't know if the board has guidance, particularly what they're looking for in terms of the building. But if there's any, I guess we're a little unclear as to the direction the board would like us to take there.
Well, I mean, I'm kind of looking at what the concerns are, in part from the community, but I'm also looking at if the nearby buildings are 150 feet and yours is more than twice that height, and you can accomplish a project that doesn't take full advantage of every square inch of height that's allowed under FAA, like, why do you have to go to the tallest possible height, right? Now, to Commissioner Shabetta's point, it's very likely that the community concerns about the height of this building would never be satisfied by you using up all your floor area, right? Which you're entitled to use. But it seems to me there is a building that might be more, let's say, more sympathetic to the neighborhood and still get all of your floor area and still get amazing views and still get as good of a project, if not better, than this sketch. Really, that's all we see is a sketch. I don't know if the project has been further developed than this sketch.
I'll just say this is the project that the client intends to build here, and it's complies with the zoning. It does go up to what the FAA approved. But this is a large site that was specifically zoned to handle a larger building. It's surrounded by streets on all sides, and it's tucked into the corner of the neighborhood near the highway. And I think it's a little unfair to fault the applicant for taking advantage of the zoning that was specifically put in place for this site.
Well, it's not faulting the applicant for taking advantage of the zoning. The zoning doesn't really allow this project, right? The zoning says you can only have a building that's 100, whatever it is, 70 feet, right?
Due to an FA, due to a air safety requirement.
Yes.
I don't think that the chair was placing any fault. I think the chair made a simple request to explore other ways to get all your floor area without creating the same type of height where you still have all the benefits that you're having now. I don't believe that that's an outrageous exploration. I think it might actually serve a benefit.
I can speak to the applicant team about looking at that, but they've already designed an alternate setback building, which in theory is supposed to preserve a little bit more light and air around the base of the building. If you do a non-alternate, a standard setback building, in theory, you could have a lower building. I mean, it could still be the same height. Obviously, it's a height factor district, so there's no absolute height limit. But then you're going to have a greater impact of light and air at the street level. So this is just a large irregular site, and the applicant has designed it in a way that they think is appropriate and fits within the zoning.
Well, see, part of this problem is you have obviously significant community opposition, and it doesn't look like there's been any, maybe I'm wrong, doesn't look like there's been any kind of give and take or discussion with the community to try to assuage fears. For example, I know that sort of the adage of the tower, sort of the tower in the park concept versus the bulky building with a wide footprint argument is often made for the tower allows more light and air, but this isn't really a tower in the park, it's a tower on a base. So you're not sort of getting the benefits of kind of any of those things. And the concerns that the community has might be responded to if there were a better dialogue with the community. And it doesn't sound like there is any. So, and I'm trying not to ignore community concerns because you get to check the box that the FAA says you can be 375 feet tall, and therefore you are, right? Because we are looking at the findings which require benefits versus disadvantages to the community, right? And you're not, other than a simple sentence in your statement of facts, you're actually not explaining what the benefits versus disadvantages are. And the findings in 7303 specifically refer to light and air, right? So it says privacy, quiet, light and air in the neighborhood of such use, of such bulk. So you need to respond to that. You can't just ignore it.
Well, I'll talk to the findings in a second. In terms of community outreach, I mean, this project, this site has been in front of the community for quite some time. There was a variance proposal a while back, many years ago, which was strongly objected to by the community, and perhaps that set things down the wrong course. But we've been before the community board. It's very clear that they're opposed to a development on this project. And I think even a smaller building, they would still object to it. It's a very large site, and it's R6 zoning. And it's that zoning for a reason. But everyone who's opposed to this project lives across a street from this project, which in most cases, when it comes to opposition in New York City, is a rare luxury to have a street. So I just don't know what purpose.
Sorry, it's a luxury to what?
To have a street between you and a development going up in the city. I mean, that's usually opposition. It's
a building going up right next door to you and perhaps blocking a window. But that's not the case here. We're surrounded by streets on all sides. So it's a little bit different than usual. And again, this is what this site was zoned for. It's going to be a large building, no matter what is the fact of the matter.
Well, you do need to address how there's advantages outweighing disadvantages to the community.
We can. Sorry to cut you off, Chair. We can elaborate on those findings in the statement of facts. I mean, this is a long, vacant, underutilized property. The applicant has spent millions.
No. The advantages of the waiver against the disadvantages, not the advantages of developing a vacant site. Obviously, the advantages of developing a vacant site, you can put a one-story taxpayer on it, and that's an advantage to the vacant site, right?
Understood. And we can elaborate on that as well. I do want to point out in our statement of facts, we took the position that in this case, that general finding doesn't precisely apply. And I understand that you don't agree with that, Chair, and reasonable minds can disagree, but whether—
No, let me correct you. It's not reasonable minds disagreeing. We're the board. We decide what the applicable regulations are in our purview, and 7303 applies to all of our special permits. So it's not about reasonable minds disagreeing. So
no, all of those—
we're the deciders in this situation. So you need to address 7303 with respect to the requested waiver, disadvantage versus advantage.
I guess the point I was trying to convey, Chair, is that of course all the general findings of 7303 apply to any special permit, except to the extent they don't to that specific project. As you know, a number of them usually don't apply because they're very specific public improvements and things like that. The point I was trying to make is 7303A deals with bulk modifications. And one could argue that this is not we're not requesting any modification of the underlying bulk regulations. We are coming up with the R6 district regulations, whether or not we're a foot above what the FAI height limit is, or 260 feet above. That I don't know if it was drafted that way to mean it's a bulk modification in this case.
Well, Council, with all due respect, as a matter of practicality, I think it would be better to respond to the chair's request as opposed to push back against it and prolong this hearing.
Chair Shabeta, understood. Also, we will respond to it.
7360 is entitled Modifications of Bulk Regulations.
And that's what its title is.
And then you look at 7361, but okay.
I wouldn't view the title as dispositive, but to Chair Shabeta's point, I like I said, we will expound upon the finding. We will.
Okay.
I was referring to exploring alternate design. This can go, if you speak to your client, I'm sure everything is under a cost benefit analysis. And I think that it would be a greater benefit to explore the alternate designs that is being suggested by the chair, as opposed to sticking by your laurels and saying this is what they wanted to design. I think that's just a benefit to the client, but your client will do what he or she decides to do.
Understood.
Can I just step in and say something? I think one of the things that I would like the applicant, I mean, if it helps the applicant in its statement, is that this is not a typical square site. It's an unusual triangular site that has a very wide boulevard on one side, which is Northern Boulevard. And across Northern Boulevard are all the other Tower in the Park development. And along 112th Place, which is the only narrow street, which is 50 foot wide, which is of a lower density, has the lower buildings. And the remaining frontage is the approachway to Grand Central, Northern Boulevard, the whole spaghetti of the whole highway network right there. So I think it is, the site is very hemmed in by all the various networks of roadways. And so in terms of its approachway and its frontage, they're only very limited street. And I can understand from the design, and I think applicant should help, if it helps, to build up the 1/12th place is not going to be your main entranceway, and you want to set the building back, which is what your building has done in your design. You have tried to push the building back as much from 1/12th Street because that's where you have the smaller buildings, and you have tried to push it away. And Northern Boulevard being a wide street, you have maintained a respectable distance from the curbside. Try to use those arguments as to say what would be the difference between if you were to plunk down an as of right building, which maximized the entirety of the lot, that would comply with 150 FAA height limit. I would approach it that way, as opposed to a building that is trying to be respectful of the neighborhood context and is setting the building back away from the masses as much as possible, and yet trying to be complying with the underlying zoning, except for the FAA height limit issue. That would be my approach to the argument, because this is an unusual site and it is right next to highways. So you cannot have, it doesn't make sense for the building to be right next to the highway with all the windows facing that. So you have to be respectful of all the constraints this site is seeking. And I think we need to be mindful that this is not a project where we are reviewing the project design its entirety, because there are too many complexities to it, and that's not what is before us. The applicant in its own, I think it just is a matter of walking us through the argument, kind of saying this kind of addresses the elements of the light air safety. And I am convinced from this project that it does, but you need to kind of just spell it out in your narrative.
Understood. Chair, if it's okay, I'll let Brett McKay, the project executive, speak to the violations towards the end of the presentation, unless you want to do it now, but we should probably turn it over to Mr. Pittman for the FAA presentation.
Okay.
Good morning.
State your name, please.
Clyde Pittman.
Okay.
Well, I heard in the beginning that I only had 3 minutes to give a presentation.
No, sorry. I didn't know. It was very confusing. I thought you were a member of the public to come to speak. I didn't know that you were on the team.
Okay.
So go ahead.
I was going to abbreviate everything and just get to the questions and skip all this. Okay, so we're going to be discussing this the property that's located at 112-51 Northern Boulevard in Queens, New York.
Mm-hmm.
Next slide. So when the FAA does their analysis, it's the whole purpose of this is to protect the public, the flying public, against unannounced objects. And there are certain requirements necessary to notify the FAA. One of those is being 200 feet above ground level. This building is in that category. That would require automatic notification. The slope from the runway, on airport construction, or construction within an IFR procedure area. So the first one is the initial reason that the building required notification to the FAA. Next, please. So Part 77 establishes requirement for obstacle identification, and so they can be charted so to keep the aircraft pilots aware of where objects are located. And it determines potential hazards and effects that you can use to mitigate by applying obstruction lights to mitigate it to improve aviation safety. So, to chart these, which the object, believe it or not, has already been charted by the FAA and appears in the FAA's obstacle database. And I'll show you that picture as we move along. It allows
What do you mean the object? This object?
Yes, it's already charted.
Okay. In anticipation of it being built.
Yes. So it's like the Ferris wheel that was going to be built in Las Vegas, and they eventually changed their mind, but they put up 2 big posts So it had a foundation and it was up there. So the FAA is now charting that at 500 feet, and it's really only about 50 feet above the ground. So, and it's been that way for quite some time, and it affects instrument procedure design. So this, the FAA, the Part 77 allows the FAA to identify potential aeronautical hazards in advance and prevent impacts to air safety. Next, please. So the FAA will attempt to negotiate with the building sponsor, which they did in this case, and had them, their initial height was 387, and they lowered it to, for AMSL in NADV 88, and they lowered it to 376, which is what the FAA did. Will issue a determination on proposed construction for all notifications. They'll either issue a no objection, a conditional determination, or an objectionable. In this case, and I'm going to go through the process, they did a step procedure and they initially issued a notice of presumed hazard. And that was based on some of the concerns that were brought up today, and which resulted in them lowering the overall height. But when they put this out for public comment, and it was out for 40 days for public comment, they received no comments from the pilots, the airlines, or the public. No comments were received at all on this project. Next slide, please.
Can I ask you a question about that? So when sort of this announcement for public comment is put out, is the assumption that pilots are paying attention to both construction projects in the route of their usual flight paths, and that they would comment?
Yes, the airline association makes comments and notifies the different airlines, but the airlines themselves are very aware of the FAA's website, where they publish the proposed obstacles, and then they would make comments on it. So yes, they're published out there, and not only, and as far as small aircraft, you have the AOPA, which is the Airline Owners and.
But this one is kind of an echo.
Sorry, I'm sorry. Someone just joined. You must turn off your YouTube video and mute yourself. There we go. Thank you.
Yeah, AOPA is Airline Owners and Pilots Administration or organization. And they keep track of all the proposed objects that are being proposed in the area. The FAA distributes, lets people know on their website what objects are proposed, and they can feel free to make any kind of comment they want. The only comments they will consider, though, are those that are directly related to aviation matters. So if you don't like the color or you don't like the shape, that really has no bearing. It's whether it's going to impact aviation is necessary. So the chart you see in front of you is the basic. Lets people know on their website what objects are.
Whoa, someone has their YouTube video on who just entered. Please turn it off. You must turn it off.
So the chart you see in front of you is the process that the FAA, when a project comes in, a proposed object comes into the FAA, it gets initially logged in by the Obstruction Evaluation Group. And then on the right side, it shows that it's processing down through the different services within the FAA. You have airports, you have flight procedures, you have technical ops, you have the military, right? And frequency management, and it's a little blurry. And well, anyway, that's the different organizations that go through this. Then it goes back to the screener in the FAA, the airspace specialist. And then he tries to do some negotiation with the sponsor. And if the sponsor will agree to certain limitations or certain changes, if it has to go through notification, then it goes back through the process again and is distributed to the public for comment. And after that, it would, if depending upon the comments received and their evaluation, it would be issued a notice of presumed hazard, or it would be issued a presumed or a notice of determination of hazard. So one of those two things are eventually the results of this. And in this case, it went through the process and it was received initially a notice of presumed hazard, and then it had a determination of no hazard. The finding.
So what's the reason for the presumed hazard initially, and then it goes to no?
Good. The reason for a presumed hazard would be a penetration of a obstruction surface. So in this case, the penetration of the obstruction surface that occurred was the horizontal surface, which is at 171 feet AMSL. So that would automatically trigger a notice of, or a notice of presumed hazard. And then it goes through the findings, and the findings at the height that they requested show that there was, at their height, it was a notice of the diverse departure A off of runway 13, which was brought up earlier here today. And that was mainly it of all the impacts. It does impact circling, but the circling really is just a flag at this particular airport, or at other ones like Miami, where they don't allow circling at all. And circling to land, they would, for an aircraft to circle to land, they would have to shut down all the incoming aircraft while the aircraft executed its maneuvers. So it would take, I don't know, it would be a severe impact if they actually did circling at LaGuardia. It would stifle air traffic into the airport. So they have these presumed hazards. With this one was of an obstruction surface, and just because you penetrate an obstruction surface doesn't equate to a hazard. It has to be something more, usually an electromagnetic effect, or it's an IFR, instrument flight rule procedure, that would trigger that as a problem. So after those were resolved by lowering the height, then obstruction marking and lighting, obstruction lighting on the structure itself would clear the impact to the horizontal surface. There are roughly, I don't know, probably 100 objects in the area that penetrate the horizontal surface. It's penetrated all over the place at this airport, and so obstruction lighting going on the structure would clear up that impact, which was the two things that occurred here.
So do you know the reason that they let objects penetrate the horizontal?
No impact.
No impact.
No impact. There's no impact here. In some locations, if you have a like a VFR airport, a visual flight rules only, there's no instrument procedures. And let's say there were no penetrations to the horizontal surface. There's two surfaces. There's the VFR horizontal, and then there's the IFR horizontal, which is much, much larger. So in a smaller airport that would have the VFR horizontal and there were no penetrations to it, well, it wouldn't get approved because there's no penetrations to it. But if you've already got penetrations from, that are a mile long, one little small penetration isn't going to matter whatsoever because they're not using that procedure and they're not flying it over.
Okay.
Those would be the reasons.
So that would account for why a penetration that's 100 feet more than what is typical of the horizontal would be accepted in this region, because there's so many exceedances.
Exactly.
Okay.
Next slide, please.
I have a quick question. How long does this process generally take?
How long does this process take? Is that your question, sir?
Yes.
It is. I forgive the background noise.
Okay. How long a process takes, in the perfect world, it should take only 45 days. But in this particular case, I'm sure it took probably 9 months for the process to go through. And that depends upon the workload and the coordination that's involved. As I showed you, some of those offices, the airspace functionality is other duties as assigned. So they're not dedicated to as much as air traffic is to providing responses. So it can sit in someone's basket for a while before it gets used, or it's very, very complicated and the airspace requires a significant in-depth analysis. So 90 to 120 days is considered pretty good.
Okay.
So once the determination of no hazard is issued, it's valid for 18 months. An extension can be requested and you can get an additional 18 months, but you only get one extension. But once you file the notice of construction has been filed, then that prevents the determination of no hazard from expiring. It will stay active until the project is built or it's abandoned.
So with respect to that then, If the FAA has already put this on the charts, is that the reason it endures? Because it's already on the charts, so pilots should be aware, look out, there's something taller than you expected?
Yes, and also it's to notify flight procedures not to design anything that would be impacted by the structure that's going up. So when they go to design an instrument procedure, they would have notification, oh, I've got to account for this in my design. So once it went through that process and it was locked in, and so any other design work on the procedures or changes would have to incorporate that building.
Now, this determination of no hazard, if you were to build it higher, obviously it'd be in violation of that. If you were to make it lower or make any other changes to it, would that have any effect?
Well, and if you filed it at lower, then when you're filling out the part 2 of this, which is reaching greatest height, then you would tell the FAA that this is the height it is. If you go over that number, it will not let you fill in and file that form. You would have to go back and refile if you went over it. So once you file the start of construction, as I said, the FAA assumes the building is constructed and the airspace does not change. Next slide, please. So this goes through the actual schedule. So the determination of no hazard was issued on the 17th of November, 2016, and it was scheduled to expire on May 17th, 2018. The part 1 was filed in April 12th of 2018 with a follow-up dated December 31st, 2020, which is coming up. If construction is completed before December 31st, 2020, then you would file the part 2 construction complete, reaching greatest height. If it's not completed before December 31st, 2020, then a new follow-up date will be assigned. So the FAA is going to issue a comment, called a PSR, and the PSR is basically a request for more information. So then you would fill that out and send it back in, and then it would be updated by the FAA.
So that Ferris wheel, how long has it been not constructed and still showing on the charts?
5 years at least.
Okay.
Next slide, please. So as I talked about earlier, the obstruction surfaces are the horizontal, the conical, the primary, the approach, and the transitional. Some of these are in the same zoning rules that you have, but the horizontal and conical surfaces are significantly larger, and they start at a central point on the airport as opposed to the end of the runway. The approach surfaces are in the transitional. Well, approach surfaces is basically the same as what the FAA would use, and the transitional just gets truncated a little bit more, but it has the same slope requirements as the Part 77. Next slide.
But these standards, these are not the same as the zoning resolution in terms of what's horizontal, what's approach, what's transitional.
Well, they have the same heights. They have the same heights, but they start differently. What you see here, the cyan color is the actual horizontal surface of for this airport, for LaGuardia. And the arcs, the curved area starts 200 feet off the end of the runway, and it goes out 10,000 feet, and you subscribe an arc, and you do that for all the runways, and then connect them with a tangent line to the circles, to the arcs.
Can I ask you a question? The architect on their drawings did not provide a zoning analysis using the standards that are in the zoning resolution for horizontal, conical, transitional. Could you do the same for using the zoning standards, which are different, I think, than the FAA standards, just so we have a complete document so we can see the difference between what would have been allowed as of right for this building versus what you're studying under the FAA? Because what's weird about this special permit and that it comes to the Board of Standards and Appeals is that the zoning resolution never caught up with, as you know, the FAA. So we're looking at these kind of antique standards for an as-of-right project, and then being asked to compare them to FAA contemporary standards. And usually we see them on the document together.
Once upon a time, when I was before you with another project, you asked me the same question. And you asked me if the zoning rules that you had were adequate or were they obsolete. They're just different. They're not obsolete because they were what the FAA was using back in the in actually the 50s, but the horizontal surface is so much larger, it will catch more, and it'll give you a better chance of looking into something that may need further analysis. So if we did an aeronautical study, aeronautical impact statement for the client, which covered those same zoning rules. Were you issued given that?
No, if you could just give us that might solve the question, because we don't have it on the architectural drawings. What we have on the architectural drawings in the first submission were these teeny little diagrams that were impossible to see. And your graphic methodology is much clearer. So if you did that already, then that would cover the as-of-right zoning issues.
Yes, ma'am. I could ask the client to forward that to you, and I'll forward a copy of it. Do you want to do that right now? Yes. We'll forward the copy of that document to the client, and he can email you with it.
Okay, excellent. Thank you very much.
You're welcome. It's not labeled on this, but there's a little red dot that's in the right there. That's where the proposed building is going to go, and it's inside the horizontal surface. But as I'll show you in another slide, there are many surfaces that are objects that paint that object. Could you next slide, please? And here are the objects that are in this area. Now, these would be penetrating the Part 77 horizontal surface at 171. These are the objects that are around the airport right now that penetrate that surface. And you can see just in the area of the approach to runway 31 that there are a significant amount. And the arrow is actually pointing to the charted building, which is done under 2016 AEA 6286 OE. So it's in the FAA database as charted.
Mm-hmm.
Next slide, please. Now, everyone worries about an aircraft having a mishap on takeoff, such as an engine out that happened in your city some years back. And this area is protected both by the Port Authority and objected to, but it's not part of Part 77, but usually the Port Authority, it's my experience, watches for penetrations to the escape route. So what you're shown here in the red color is actually the escape route for an aircraft that runs into an engine problem. That's right, an engine out.
Ah, okay.
Next slide, please. This is your Part 77 surfaces. Now, both runway 4 and 22 and 13 have precision instrument procedures, which are the 50-to-1 surfaces. The first 10,000 feet are progress at a 50-to-1 slope, and from 10,000 feet on, the transition is to a 40-to-1 slope. In the case of runway 31, which is just to the north of where the object is, it is actually a 34-to-1 because there's so much clutter in that area, which you saw from the previous slide, that a 50-to-1 slope is just not possible. So it's a 34-to-1, which is still qualifies as a non-precision approach procedure, whereas the other ones are precision approaches.
And the precision approaches are when there's something like an engine out or precision?
No. Those precision approaches represent the type of instrument procedure that's associated with that runway.
Ah, okay.
So if you have an instrument landing system or a some of the other modern GPS types of systems, they will have a precision approach assigned to them. And you have ILSs, instrument landing systems, I saw several of them installed at this airport, but you can't get that kind of minimums at the on the approach end of 31 because you simply have too many things in the approach, including the waste transfer building for the Port Authority.
Mhm.
Okay, next slide, please. Now, there was some concern here about the departure. So what you see here is the departure surface for runway 13. So the aircraft starts at runway 13 and they have wheels up at the 31 end, and then they proceed along this this surface at a 40-to-1 slope. Now, that's why what's instituted here is a climb gradient of 280 feet per nautical mile. And that goes out for approximately 2 nautical miles. And then the whatever the height of the aircraft would be at that point, then you measure to the perpendicular line from your site to the perimeter of this trapezoid, and you divide that number by 40, and that gives you your allowable height in diverse departure A, which is where the concern was with the FAA. So there was a question earlier about aircraft turning and going south. Well, the diverse departure A is what takes care of that, because they have to climb to 500 feet before they can make a turn. So the aircraft has to be 500 feet in the air prior to it making any kind of turn. And the minimum climb for departure is 280 feet. So in roughly 2 miles out, that would be a point where the aircraft would be permitted to, maybe a little closer than that, probably 1 3/4 of a mile, would be where the aircraft would be permitted to make a turn.
What if it can't climb for some reason?
Well, then you have if it's a mechanical problem, then that's the engine out area, that trapezoid that I showed you earlier. So as it's making its climb out, and most aircraft can climb 500-600 feet per nautical mile with no problem. So so as it's climbing out and it has suffers an engine problem, it's still required to make a certain kind of climb. 62.5 to 1 is the climb of that, is the slope of that surface, and the aircraft is still required to climb out at an accelerated climb rate. But if it can't make it, if the aircraft is physically, with all engines operating correctly, if it physically can't make 280 feet per nautical mile, it has to select a different runway.
Ah, okay.
So if you can't do that, you can't take off on that runway. You must be able to make that. And like I say, most aircraft, are easily able to do double that when they take off from the airport. Now, I did have a movie here showing you it was a runway 13 departure, but if you wanted to show that, but I think you've all have seen it, right?
Yeah, but the public hasn't seen it, so and they're so wonderful, those movies, so we should share it with the public.
So if you could show the one for 13, then we could do that.
Okay, so he's going to do that. But in the meantime, can you? So we had I had the question about what about that runway 31 in terms of high winds, flight path changes during the U.S. Open, and circle to land.
Right. Well, we've already talked about circle to land.
Okay.
Okay. So the issue. Well, here we go. We're going to start. Point out the building. The building is in the upper right-hand corner. Move the cursor over to the right.
Oh, the white box.
That's the box. That's the proposed building.
Okay.
Okay, and you can see we've got a slight turn to the right here, and this is an actual flight path of an aircraft on the typical. This is the typical flights that occur. So if you could give that a go.
Takes a little while for it to rev its engines.
and we've already missed the building.
So the building was far to the right is what you're
Far
saying.
to the right, yes.
But we don't even see it in this image. I mean, once you take off, it's outside of your field of vision.
Right, and it's also it's outside the trapezoid. So once we get up there and climb, we're done with it. If you want to go back again and see that one more time at the beginning, okay, and see the building, now just keep your eye on it, and it will move very quickly as we go down the runway. It will disappear as we get past that, as we vector. See, there's the building, and now
Yeah.
we're up.
Yes. Okay.
It's off to the right, and this is a typical, probably worst case for the standard left turn out of that runway. And we're gone.
Okay. Now we come back.
I've just received a note that the special aeronautical study we did has been submitted to the board. And so if you want to show that, I can walk you through the surfaces that are in your zoning requirements.
Okay. Not sure.
Here's the building down there. See it? See how tall you are if you're coming over it?
Mm-hmm. Okay, so that box is the building. Okay, got it.
Right.
Okay. Great. Thank you very much. Very helpful. Commissioner Arlie Brown has a question. Go ahead.
So that trapezoid that you see does that encompass all of the variations of how a plane would come off of that runway? Is that basically what it is?
If we could go back to the slide presentation, I can show you. If you go to the next slide.
Mm-hmm.
Okay, this is the takeoff minimums. These are the numbers that are what your aircraft has to do. So yes, that trapezoid is basically standard for all kinds of areas. It's called the initial climb area of an aircraft. So if you read the first line in 2015, it says these first two numbers, the 400 feet ceiling, that means the cloud's got to be at least 400 feet tall, and I have to be able to see 2.25 miles.
Mm-hmm.
Or standard with minimum climb of 280 feet per nautical mile to 500 feet. So that is, you look down into 2020, you've got the exact same wordage on that. So it hasn't changed. So that trapezoid is basically standard. It shows a 280 feet to 500 per nautical mile. The aircraft has to climb to 500 feet before it can turn. Standard would be climb until I was 400 feet above the runway, and then I can turn.
Mm-hmm. Okay, thank you.
Okay, next slide, please. Okay, now in this one here, this is a runway 13 departure with diverse A. Well, you already saw that, didn't we? Yeah, we already saw that.
No, not in that form. I don't think that was on another slide. You saw a plan as opposed to this this perspective view.
Well, this one here is I don't know if it's out of place or not, but this is the same one, the 13, and the building is off to the right. That's the same image. What I wanted to address your concern of the aircraft coming in on the expressway visual.
Mm-hmm.
Okay, and that would be the next slide. We can skip this one because it's the other movie that we want. Now, this is the procedure as it was published in 2014. It has not really significantly changed. So when the aircraft is coming in it's going to have off the left wing, it will have that is flying the expressway visual. It'll have the proposed building will be off the left wing, but it's going to be right just under at closest point 1 nautical mile. And a nautical mile is 6,076.11548 feet. So it's just under a nautical mile from the building itself on the flight path. So if there were some gusts that would be maneuvering the aircraft, it wouldn't push it a mile off. That just wouldn't be. Okay. They wouldn't land there then. Mm-hmm. Okay. So if we go to the next slide. This is in 2020. It's basically the exact same diagram, except what they're focusing on is the localizer that's associated with runway 4 to provide them the guidance and make sure that they stay at a specific route as it comes in at this 45 degrees as it's coming into the airport before it makes the turn at Dalles, which is by those twin fuel tanks that are sitting out there.
Mhm. Oh, that's how it knows to begin its turn.
Yes, so it
Okay.
passes those fuel tanks. And there's
Mhm.
also a waypoint, an invisible point in space that has a name called Dalles, and that's a specific latitude and longitude. So when they cross Dalles, then they make that turn. But most of them would be flying visual on this, and they look for those twin tanks.
Okay.
Next slide. I think this is the movie here. Yeah, this would be the 31 departure. So if you could do the other movie.
And while this is happening, I just let someone into the waiting room. The person I just let into the waiting room, please turn off your YouTube video before we can hear it.
Okay, so this basically is going to, you see the building straight ahead, the little white dimple that's sitting up right there, exactly. So as we're coming in, we're flying the river visual, or the expressway visual, excuse me. Notice that there is some undulation in the air, so there is some rough air coming into this at this point. And this is an actual flight track of an aircraft.
Oh, that's the camera underneath the plane that we watch?
No, I made the movie, but
Okay.
it represents the red line on top is the actual path the aircraft is flying. And this
So
is
where are the tanks? Are we seeing the tanks yet? No.
I think we've already passed the tanks.
Oh, okay.
Now we're getting ready to approach the Shea Stadium.
Yes. Yeah, and there's City Field. So that was the question, is what happens when you're not allowed to fly over City Field?
Well, they wouldn't be using this approach. They would have to go to an alternate runway.
So it wouldn't just be a wider berth in one direction or the other?
Well, the width of the trapezoid that they're allowed to fly, if they're making the approach over this over City Field, is rather wide. It's very robust as far as the width, because when you're flying visual, there's a lot of play that and while he's on the course, he's fixed because he's flying the localizer. But once he makes that turn, it depends on where the aircraft is, and if you want to make it short, it's going to be a little rougher ride for the passengers, and they'll make a sharper bend coming in with the wing banks. But they would have to, if you're not going to fly over City Field, most everything is all the instrumentation. It all generally passes over that. So I would say they would end up shutting down 31 and 13 for departures. So they'd have 13 landings and landings on 4 and 22. So you wouldn't have much of an operation on 31.
And even if the wind is telling you need to use a particular runway?
Well, that's how they decide what runway to do.
Right.
If it's closed and they're not allowed to do it, I don't see many ways you can use that runway. Even if it's the prevailing winds, they would have to use more power.
So in other words, don't fly into LaGuardia on days when tennis opens up.
Well, I wouldn't say that. I say no matter what the FAA does, it's going to be safe. So, you know, I wouldn't presume that it would be unsafe at all. So we saw the movie here. So you saw what happened on the for the arrivals and the departures. Next slide, please. So this is what we sent in to the basically to the FAA. We sent a boundary of sorts over the property as we understood it, and that's what we filed with the FAA. So whatever building they're going to put in, it has to be within this trapezoid, or it would not meet the design of the approval process of the determination of no hazard. It must be within this trapezoid. So we have a couple of other examples, and it can't exceed the height either. So if you look at the next slide, we have some examples. You can have a square building, you can have a round building. As long as it stays within the boundary of that and does not exceed the heights, because some points on that trapezoid got higher heights than others, but the 376 is the lowest height across the whole piece of property. So at the south end, it would be maybe 4 feet higher, but nonetheless, that's the limitation right here for that diverse departure. One more slide. These are some other examples of buildings that are possible that would fit into this area. What they design is basically, as far as aeronautics is concerned, is irrelevant as long as it stays within this trapezoid.
Right. Very helpful. Thank you. Fascinating always. Thank you so much.
You're welcome.
I think what we should do is just hear from the team if there's anything they want to add, and then go to the public, because there are a lot of people waiting. And then if we want to go through the zoning analysis, we may not need to do that with you, because we'll take a look at the materials on our own. But thank you very much about what you just sent. Okay.
You're welcome. Thank you.
All right. So Mr. Travers, is there anybody else on your team you'd like to have speak?
Well, Chair, you had a question about the violation status, and
Yes.
Brett McCabe can speak to that now, or I guess it makes sense that he speak now.
Yeah, please. Mr. McCabe, state your name.
Brett, you're on mute, Brett.
You're on mute. Oh, I'm mute. I'm sorry. I muted everyone, I think. No, you muted yourself. Unmute yourself. There you go.
Brett McCabe, on behalf of the project owner, I'm the project executive. Good afternoon, Chair Perlmutter and Vice Chair Chanda and esteemed board members. We are pleased to announce that since our last appearance before the board, we have successfully argued for dismissal of a number of the violations that you may see on the department's website. In fact, at one of those hearings where the decision was rendered and adjudicated post our last appearance, which was January 14th, we did receive a decision on January 21st. And in that decision, Judge Miraglia also indicated that some of these summonses are actually duplicative in nature. So not only was the summons itself dismissed for a lack of basically a condition that warranted a violation, but in addition, they noted in their decision that oftentimes additional summonses are issued improperly to a number of parties, and they're deemed to be duplicative. In addition to that decision and dismissal, we also received an additional dismissal at the beginning of February, which again was post our last appearance. Again, it was found that that violation was not warranted at the time of issuance. In regards to the violations that stem from a single incident of January 4th of 2019, as I'm sure the chair is aware, as well as the other board members, there was a utility failure in this area. There was a Con Edison explosion, a DEP water line leak. There was a National Grid pipe condition that created a sinkhole and a collapse of Northern Boulevard adjacent to our site. There's actually an oath appearance date of December 8th, 2020 for 7 violations that were issued in relation to that incident. And we're very confident that we'll also achieve a dismissal, as the decision we received at the end of January, beginning of February of this year was another violation that directly related to that incident. So based on the same evidence that we anticipate presenting, the same arguments, as well as the same motions to dismiss, we're very confident we will also get those 7 violations dismissed as well. And as I'm sure the chair is aware and the other board members, when you go to the department's website, you could also see that a number of these violations have actually been mitigated. So you'll start out with a violation that's originally issued, and we would argue that they're improperly issued. But even if they are deemed to be properly issued, they may start out at a value of $10,000 or $5,000 each. And then through successful argument and presentation of evidence, oftentimes those are mitigated down to, I have several instances and examples I can share with the board where $5,000 violations came down to $625. So we do feel it's very beneficial to make that appearance at the oath hearings to plead our case. Again, we're confident in the decisions that'll be rendered related to the January 4th incident. We are aware of the violations that have been issued and are outstanding, but again, we typically appear at these oath hearings and present our evidence and move to have these dismissed.
So, but you still, it shows on the website, unless it's delayed in responding, 150,000 in outstanding violations. So if that's not a correct representation of what's currently viewed by ECB as owed, you should let us know.
Well, and again, to echo my previous sentiment, Chair Promoter, if there's 7 violations related to the January 4th, and they all have a value of $10,000, prior to adjudication, you're going to see something reflected on the website that shows at least 70,000 more than it should. So that's just one example of why these numbers, number one, may be skewed. But in addition, as some of these violations would be considered duplicative, prior to adjudication, you're going to see maybe 3, 4, 5 additional violations that are all stemming from a single issuance. That maybe one was issued to the general contractor, one was issued to the project owner, one was issued to the prior general contractor. So now you've got $30,000 for one single instance of a $10,000 violation that's yet to be adjudicated.
Right. Okay.
That's why we feel it is misleading.
Okay, but the oath hearing is not until December. Why is it so far in the
We
future?
had an initial date of April 24th, Chair Perlmutter, and then obviously in light of the current pandemic, there was an administrative, adjournment that was actually issued by oath. There's one that's set for January 1st, 2020. That's the summons that ends in 72H. And then there's 7 additional that are adjourned to December 8th. And I could go through that list if the chair cares. I mean,
No, we don't want to go through the list, but we're trying to, before we make any decision on this, we want to know that you've come to some kind of an agreement with ECB or oath or whoever, because we don't.
And we certainly have no objection to that approach, Chair Perlmutter. I mean, we know that it's a Department of Buildings concern. We know that prior to a C of O, all of these fines need to be taken care of. But again, in anticipation of a successful adjudication and appearance, it's a little bit premature right now at this point to make a payment of $130,000.
Fine, right. Understood. No, we always say go to ECB and work things out. Sometimes there are payment plans, sometimes they're dismissed, whatever.
Absolutely.
Okay.
I also, just to again comment, I know that some of the board members had some questions regarding the status of construction. If time allots, I can certainly bring people up to speed on that, but it's certainly your call.
Well, Commissioner Sheta's observation correct? Construction is halted, right? You're just in excavation level, right?
We are at an excavation level. I'm actually on site right now. I don't know if you can see the picture clear enough. I'm in the job site trailer. We've actually got a machine right now moving some of the earth in the area. We did install the perimeter liner walls as well as some of the foundation walls. We have DeSimone as our structural engineer on board, as well as TVS Design and Architecture. They're actually incorporating the SOE system and foundation walls right now into our structural design. We're in the SD phase. We feel like that'll be completed in the next 4 to 5 weeks, and then we'll jump into the DD phase. So obviously, in consideration of the winter weather and then the overall pandemic and halting of construction, we have kind of sat in a stagnant sense, but we do continue to monitor the site. We obviously come by and perform remedial measures of safety, installation of barricades, orange netting, protection of the public, etc. But we do anticipate SD phase completed in the next 4 weeks.
What's the status of the design drawings?
The schematic design drawings are currently being prepared right now. That's a combination of TVS Design and Architectural as well as DeSimone. The overall duration of that, we're about halfway through, so we feel like we've got probably about 3 to 4 weeks left in that. We've got design documents that'll come immediately on the tail of the SD documents. I think that's got a phase of somewhere between 3 and 5 months when you take into account both the TVS portion of work as well as the DeSimone portion. And that's also going to encompass the MEP design as well. As you can imagine, it's kind of a cohesive process between incorporating the MEP design, the stormwater, the sewers, et cetera, with the structural and overall building design.
But you're only in schematics, so how are you 50% schematics? So that's much less than what we're seeing on, we get these sort of strange little line drawings that don't tell us anything about what the project actually looks like.
Right.
You have more information. I mean, I think one of the reasons that the community is so upset is they don't know what's going on. And the drawings that we see for this application are so minimal that it looks like you don't even have an idea. And actually, the last submission we got, it said on the drawings for informational purposes only or something. So it made it look like you don't even have a project design, right? So
I can understand that. Quite frankly, though, Chair, that's why we're before the board today. I mean, we felt that we are anticipating hopefully a successful resolution to this and the granting of this special permit, certainly based on Mr. Pittman's presentation, as well as what we feel is compliance with the as-of-right zoning. Obviously, we would like to move forward with further design. We have passed along to the board those renderings as we have them available, and we're certainly happy to continue to pass along additional information as it's designed. At this stage, we're in the schematic phase.
What renderings?
We sent over a visual representation of what the anticipated look of the building will be. That's how the chair described it. You described it as kind of a 60s modernist feel and design.
No, those aren't renderings. They're line drawings that are barely schematics that looks like if you have Form Z, you could just draw that really quickly and you'd have a project that looks like you have a building, but it's just outlines of a building. If you actually have renderings of a project to share with the community, that would give the community a little bit of comfort that they know what's going on. It's like because yeah, I mean, if all we see is a hole in the ground, we don't see any permits pulled, we don't see any drawings that look like they're at any level of sophistication, even remotely, it looks like the project is completely up in the air. And if it's completely up in the air, it's a different project than if it's already through design development or the schematic design. What you're calling schematic design and what I call the schematic design might be different. You might be much further along in your project than I'm imagining, but so far it doesn't look like it.
Well, again, we certainly may have a different understanding or definition of the term SD versus DD and CD, but we are moving forward with the anticipated project. It is not a 40-story building. I think one of the board members, or even yourself, may have described it as a 40-story. It's certainly not a 40-story building. We do hopefully anticipate, like I said, the issuance of this special permit. So we would move forward with that height, those alternative setbacks as we've described, as well as that overall building envelope. As the schematic design progresses, we can certainly share with the board a further rendering of what you may define as a more detailed rendering. But we have been working with TVS and D. Simone. We have obviously had to incorporate a lot of the remedial measures that were required. The sinkhole that took place certainly was the impetus for some of the redesign and challenges to do with the structural elements of the property as well. The installation of over 109 tangent pile cans certainly impacted that. So it's an evolving process, but yes, we are moving forward and we are in that phase right now.
So it's not a 40-story building.
It is not a 40-story building.
So let us know, how tall is the building?
It's 22 stories.
22 stories, however, it goes to 370 something feet, right? Okay, so some of it has high floor-to-floor heights.
Yeah, there's a very decent entranceway, obviously from an aesthetic perspective. We've chosen to keep a lot of open air in it. But again, I think as the board has echoed, in the review session, as well as perhaps during the hearing itself, we have tried to maximize, the ability to kind of use these setbacks to minimize any impact for light and air for any of the adjacent properties in the community. And again, to echo Mr. Travers' sentiment, we do have a 6 or an 8-lane highway between ourselves and the Dory Miller project, the housing cooperative units that are across the street. So we are trying, certainly with those setbacks, to minimize any impact to light and air. And rather than utilize the entire footprint, when you kind of build in this sense, we do feel like that has the least impact on the community. And then again, just to go over Vice Chair Shonda's comments, we know that a lot of this project fronts highways and entranceways and expressways. And if the board in a supplemental submission would like us to kind of capitalize or express the difference between the benefits and disadvantages of this structure, we're more than happy to highlight those as well.
Yeah, you need, it's not just being more than happy, it's a finding. You need to make those findings in order for us to make a decision. So you can't just say we comply and then not go through it. So you do need to go through it. And, you know, if the project is far along in design, in schematic design, it means that there have been design decisions made that we should know about, that the architects decided put it here versus put it here because for different reasons. That should be articulated, okay?
Understood, understood.
Okay, thank you. Mr. Travers, would you like anyone else on the team to speak? Any questions from the commissioners of Mr. McCabe? No, okay, so I would like to actually, there's a lot of members of the public currently speaking. If there are other members of the public who are listening to this on the YouTube video who would like to speak, they can dial in. But before we switch over to the other screen, let's try to tackle some of the people who would like to speak now. So I'm going to kind of one at a time ask a person whose name I see or whose phone number I see. So for example, I'm unmuting Renata English. If you would like to speak on this, please state your name and you have 3 minutes.
Crap.
Renata English.
Hello.
Hello.
My name is Renetta English. I'm chair of Queens Community Board number 3. And as you mentioned, I know that the district manager, Ms. Reed, is on the line, and also Hamlet Wallace, who are the representing the board. But since you called my name, that was some of our concerns on the board, is the fact that we did not have any actual renderings of what this building would look like. And that was definitely a true concern from us. So I can't understand why that's not available. But the official statement will come from Ms. Reed.
Okay, thank you very much. Appreciate that. Okay, I'm just going to see if I can find Ms. Reed's name. Some people dialed in with a phone number, so I can't identify them. And so
it says G.A. Reed, CB3, district manager.
Oh, it does? Okay. Reed. Does anybody find that? Kurt, if you see that, please unmute her.
Yes, I just.
Oh, I see. Okay, go ahead. I'm asking to unmute. Go ahead, Ms. Reed.
I won't time her. She's a community board.
Good morning.
State your name, please.
My name is Giovanna Reed. I'm the district manager of Community Board 3. I want to thank the Board of Standards and Appeals for reaching out to the community because this is something that's extremely important to our small community, which is comprised of over 250,000 residents, and we only take up three square miles. And the corner 114th Street and Northern Boulevard is the end, is where our district ends. And at that location, there is the entrance to to both the Grand Central Expressway as well as the Van Wyck Expressway, and surrounded by that area immediately are 4 elementary schools. We are very concerned about what is being developed there. And in response to Mr. Travers' statement that the community would not be satisfied with a smaller structure is not true. We were never presented any plans of any kind, and certainly not the development of a smaller structure. We'd be very interested in seeing what they could come up with. We're concerned about traffic. We're concerned about the height of the building. We are concerned about the fact that the developer has never really established a relationship with the community. At the end of the day, there has to be some sense of cooperation, and that's not happening as well. In addition to that, we cannot see where the overall community will benefit from this project. So these are the things that go unanswered. And I also like to say that just because there is a provision to go higher doesn't mean that you should double the project, the building in height. The average building along that stretch is about 9 stories. From what I can see, it's about 37 stories. I don't see the necessity to create a tower. If there are other ways in which the development can be done with a smaller envelope, that would be wonderful. So we're interested in seeing what else can be done. We have a cooperative, which is directly across the street from this proposed site. No one has really talked to these property owners about what could be developed. So again, Community Board 3 urges that the BSA look at this project and understand that this would change the character of our community. And is it truly necessary? Cannot this project be done in a way that would fit in with our existing neighborhood? Thank you so much for the opportunity to speak.
Thank you very much for calling in. Okay, again, I'm going to go in the order of who dialed in. I have a phone number. Last 3 digits are 243, and I'm going to unmute that person. And if you could state your name, please. Last 3 digits, 243. First 3 digits, 347. Last 3 digits, 243.
Hamlet Wallace.
Okay, I'm sorry. Could you spell your name, please?
The first name is Hamlet, Hamlett. Last name is Wallace, Wallace.
Okay, thank you very much. You have 3 minutes. Please proceed.
Actually, most of the concerns and issues that are, first of all, thank you for giving me an opportunity. I'm the chair of the Land Use Committee at Community Board 3.
Okay.
We've moved in the midst of trying to navigate the necessities of this project in order to make it much, I guess, more of a human scale and a human scale, and also based on a community side type of scale relative to the environment that we're in. Yes, we've had conversations with the architect and the development team, and also, which has been mentioned earlier, that there's been some issues because of the inability, well, not the inability, but the lack of proper drawings that we can comprehend and get a sense of what the building will be, what it will impact us, impact our neighborhood, impact traffic, environmental issues that we would like to have addressed. So, yes, we would like to have some of those items still clarified and also magnified so we can have an understanding what this community will result in getting, like any other community would be interested in terms of the issues at hand. Thank you.
Thank you very much for calling in. Okay, the next person on the list is last 3 digits, 901, first 3 digits, 718. I unmuted you. If you could state your name, please.
Hi, this is Ed Wesley. I'm president of the Jackson Heights Beautification Group, and I thank you for the opportunity to talk and to listen to the hearing this morning. I was proud to say that I was part of the Standing Together on Principles Committee, which is a one-off committee that just of community members from East Elmhurst, Jackson Heights, and Corona. That the one issue was this particular property. We have had the same frustration that you experienced this morning in terms of the lack of detail that they're willing to share with the community. Now I'm beginning to believe they don't have it. The PowerPoint presentations that they showed us, every time they showed us a new PowerPoint, they used the original and changed some of the wording, and in some cases they didn't, because this project started off as a convention center. Then it moved rapidly to a dormitory. When they realized they had to go to the state for a dormitory, that changed, and now we're at residence and hotel. Our committee has always accepted the fact that they had the right to build, and we're willing to let them build as of right. And we're glad that the BSA is going to make the final determination, because we have great confidence in your group. Now, the lecture this morning that we got from the lawyer on the flight pattern and of LaGuardia, and I started to doze off a little bit and was thinking that maybe this building will be airborne. But back to reality, then I heard about the perimeter of the trapezoid, and I said, well, I know something about that in my high school days, but I'm off the subject. We will like a fair understanding of what this is all about. We will entertain any input from the BSA that would be helpful to us in trying to make a final decision. But our position is clear, as it is of our electeds: Jeff Van Aubrey, State Assembly, our borough president, and our city councilman Moya. They are opposed to this, and they will support the as of right building. Thank you.
Thank you. Okay, and I'll go over after the public testimony what it is that the BSA is actually being asked to look at, but we'll continue. I see on screen, because he's dialed into YouTube, someone who's identified himself merely as Andre's iPad. So I would like you please to unmute yourself and then tell us your last name so I can put that here on the screen.
Yeah, good afternoon. My name is Andre. Or they come with my iPad. I'm a board member.
Okay, I'm sorry, could you state your last name, please?
My name is Gideon, Gedeon. I'm a board member, and I'm here to support everything, the board member. I've been listening since this morning, and we have the same idea about what they're doing. Developer will present nothing we asked for, okay, so it could be agreed with. Talking about the height, you never come up with the drawing to see how many floors. I have our height on every floor, so we're concerned about that. This is about 22-story building, and I believe they want to go higher than that, to 34-story. That we not agree with that. And also we're concerned about the height of every floor, okay? So to see how high the building going to be. That's why we're concerned about the zoning, about the Grand Central Parkway, Northern Boulevard, okay? The traffic going to be along the way, okay? All the concern, the board concerned about that. So this is what we're talking about. Okay, thank you very much.
Thank you very much. Appreciate your testimony. Okay. I think
Aretha.
Sorry. I'm not sure who just spoke. I had Aretha Wareham.
Yes, that's me.
Okay. State your name, please. Sorry, state your name.
Aretha Wareham.
Okay.
I work along with STOP, which is the Standing Together on Principle. We have been meeting with this and dealing with this since 2005. We've had, I don't know how many different designs coming up. When they brought in yet another architect or whatever, another lawyer or another team, every team came in with a different design. They never truly were specific with what they wanted to build. And that's all we requested from them. And yes, Mr. Wesley is on the team. He is correct. All we want, if they want to build, they can build there as of right. But I just think they had no respect for the community whatsoever. And I'm hoping that we're not going to look at this down the line and see 26 stories later because of the fact they're not being specific with their design. Oh, and thank you for allowing me to talk.
Absolutely appreciate your calling. Okay, let's see, who did I leave out? Sorry, just a second, give me a second here. Lorinda Hooks. Please unmute yourself and identify and state your name. Lorinda Hooks. Are you still there to speak, Lorinda Hooks? If you're not there, I'm going to move on. Okay, Chanel Thomas Henry. Chanel Thomas Henry.
Yes, I had joined in to listen. I'm also a member of STOP as well as Community Board 3 and support both statements from my fellow board members.
Okay, thank you very much. I'm asking Lorinda Hooks again if you would like to speak. Okay, so moving on. Sandeep Patel. Sandeep Patel, would you like to speak?
Hey, Lorinda, Ed Wesley. Okay, they're asking you to speak.
Okay, Lorinda Hooks, would you like to speak? Apparently you're getting a phone call to speak. Okay, Sandeep Patel. No? All right, moving down. Leslie Snyder. Leslie.
Just for the, Ms. Snyder is for the
subsequent hearing?
Yes, thank you, sorry.
Okay, so shouldn't be in at all, okay.
Yeah, we asked it about some.
Okay, so now we're going, so we've had everyone who responded to my request to speak. So if there's anyone else from the public who would like to speak about, Tony, can you read the address, please?
Sure, it's 2019-74 BZ, 11251 Northern Boulevard, Queens.
Okay, and if you would like to speak on this application, please dial in. The dial-in number is, sorry, is 646-558-8656. And the ID number is
She's just close to that, okay.
Sorry, please mute yourself. Or I'm gonna, maybe I'll mute everyone. Yeah, I'm muting everyone.
Okay. Let me try because I need there's another number to call. Okay.
Why is that working? It didn't work. I muted everyone. I could still hear that person, but anyway, the phone number to dial in if you would like to speak is 646-558-8656, and the meeting ID number is 997-4505-1680. So we'll give it a few seconds for people to call in. Okay, sorry, participants. All right, I don't think I see any new names. I'm going to unmute Tony. Tony.
Excuse me, Chair.
Yeah, who's speaking?
This is Chanel Thomas Henry. Miss Lorinda Hooks, who represents the Civic Association for East Elmhurst Corona, wanted to see if one of her board members, Aretha Wareham, can have the floor again to speak on her behalf.
Only if she's reading something from her, because she's already testified.
Okay.
Is she reading something? So she can submit, Miss Lorinda Hooks can submit written testimony. She's welcome to do so. but we don't have testimony 2 times from the same person unless they're reading someone
Not
else.
a problem. Where should that written testimony go?
It goes to submit at bsa.nyc.gov. Submit, SUBMIT, at bsa.bsamapple.nyc.gov.
Thank you so much.
And
make
please remember to include the calendar number.
Yes, calendar number is 2019-74-BZ.
2019-74-BZ.
Yeah.
Thank you so much.
Thank you. Appreciate it. Okay, then. So I think we've heard from everyone and anyone who might be actually on Zoom video who hasn't spoken and would like to speak, you could put your hand up and I can recognize you. Otherwise, if you're just dialing in with a phone, I actually can't see if there is no hand to raise. So would any commissioner like to add anything? If your hand raising isn't working, just wave your hand. Otherwise, I think then Mr. Travers, we can talk about the next submission.
Thank you, Chair. So I think it'd be extremely helpful if we could just run through what we will be providing in the next submission, and the board can let us know if anything.
Okay, so this is the part where, and I just want to kind of clarify for the benefit of the public before we go on, I meant to do that. The first is, this is a special permit for request from the Board of Standards and Appeals to allow a building to exceed what are considered the height restrictions when you're near an airport. So normally in this zoning district, this is an R6 zoning district, the building is allowed to reach a significant height because its maximum heights are regulated by what's known as height and setback and a sky exposure plane. So just to throw out a number, a rise of 5 to a horizontal of 1, for example, is one of the versions of a sky exposure plane. And on a small site, a building will hit the sky exposure plane pretty early in the story. But on a large site, if you just look at sort of the angle of a sky exposure plane, on a large site, the building doesn't hit the sky exposure plane for many, many feet. And so this is a very large site. If this building had been located further away from the airport, it would have been allowed to be built as of right to the height that is currently being proposed, or we think. The issue is that this building is very close to the airport, and as a result, the zoning regulation says a building close to the airport can't be higher than something like 170 feet. And if you want to build higher, and that's because the City Planning Commission and the City Council just tried to figure out something that sounded like a safe zone, that it wouldn't interfere with airport traffic. So if you wanted to build that way without going to the FAA for additional approvals, you could build to that height, something like 170 feet. However, this special permit allows you to build taller if you go to the FAA, and the FAA establishes that a taller building that meets what's known as the underlying zoning of the R6 regulations, as long as that doesn't interfere with the flight paths. The person who was described as a lawyer with a boring video and so on is hardly either of those things. He's a flight engineer specialist, so his specialty is in aeronautics and in flight paths, and I assume he's a pilot as well, or at the very least an engineer who works on airplanes and so on in some way. You could clarify yourself, but the point is, we specifically ask for that information because we want to understand what the safety issues are about building a building that's taller than what the zoning resolution allows simply within the area of the airport, whereas that engineer also has to demonstrate to the FAA that this is within the safety zone. So basically, he showed us how he demonstrated to the Federal Aviation Administration that this is a safe building height in this location, and then demonstrates to us in, let's say, more simplified terms, because none of us are flight engineers, how it is that it's complying. And we ask these questions because we're trying to understand better. And we've learned actually from Mr. Pittman, who developed this idea of the video, that what it feels like to be in an airplane as the airplane lands and takes off relative to this building. So just kind of to clarify that. So in terms of now for the benefit of the applicant, I always have this issue with applicants who are not cooperative with the community. It doesn't do you any good. You need to meet with the community. You need to be more forthcoming about the status of your project, about what it is your project is going to do. This idea of hiding from them and then all of a sudden the project is built is not okay for a project that's going through a public review like this one. It may sound like a simple, oh, we check the box on FAA, but it's not that. You did come to the BSA, it's a discretionary approval, and you must make presentations that are truthful to the public. Otherwise, I, for one, wouldn't be able to support an application where the public has been, where the project has been concealed. So for one, the drawings need to be much clearer about your design. If you're all the way up to 50% of schematic design, then it sounds like the architects have been showing their client what it could look like and how it's laid out and so on. We should see that, and so should the community. The other part of it is, to Commissioner Shabetta's point, if you were to design a building that was less tall, for example, or kind of rearrange some of the massing, maybe there would be a disadvantage to the community from that perspective. You know, for instance, as was discussed, you've pulled back the massing, it's sitting on a low base, you're pulling it back towards the highway and away from the residents. If you made a lower slung building, what would that be like in the neighborhood? It would still be tall, right? Because at the same time, I want to say that this very large site has a lot of floor area, and they're entitled to, the developer is entitled to use their floor area as of right and not leave it on the table. Okay, so you should be showing us and the community essentially what you studied. You know, you looked at a building that was shaped like this and decided not to build that, not to pursue that building. You decided to pursue this building for a reason, and you're arguing that it is more sympathetic to community concerns. So that. And then, of course, we talked about you need to establish that the building you're proposing complies with the R6 regulations, and it has to be a clear set of zoning drawings, as you would have to submit to the buildings department to show compliance with the zoning drawings. That includes what I believe Mr. Pittman submitted already, which is the zoning for buildings located within a certain distance of the airport are required to show that they comply with the horizontal and the conical and the transitional surfaces. We never saw that for an as of right building, which I believe Mr. Pittman has provided, but just make sure that that's what it is, because none of us have had a chance to open that and see actually what was submitted. And what did I leave out? Commissioners, did I leave out anything?
Violations?
Oh, yes, obviously. So we're not going to move forward on anything on this until we know that there's been something worked out with ECB and oath. That's a basic standard of the BSA. So it gives you plenty of time. Okay, so, and then the other part of it is updating the survey. Call the surveying company Ask them to update the survey to reflect NAVD 88, which, by the way, architects, if you're at the schematic design stage and you are not using an updated survey, I feel sorry for you, because I have worked on projects where the architect didn't do that, and then DOB catches it months and months later, and it's the architect's responsibility that none of the heights are right. So do that. What else? I think that was it. Anything else? Did anybody see? Okay, and then obviously clarification. Yeah, I see Commissioner Shanda, hands up. Go ahead.
Just a clarification from my understanding in terms of what are we expecting the applicant to provide with regards to the ECB and the oath violation clearance?
So I need to see that they have worked something out with ECB. We often see that. There's a payment plan, there's a deal that's worked out, there's something where it's clear that they're going to be complying with the requirements to either pay or pay less or whatever. We often get those. Sometimes they just pay them, and sometimes they say we worked out a payment plan, or they reduce them by 50% or something, and we paid down the first bit.
So in this case, the applicant, I think Mr. McCabe stated that the next oath hearing is in December.
Right.
So not that I understand the oath process, between now and December, can they work out a payment agreement without having to go through the hearing?
No, they want to go to oath. Well, the point is that we're not going to make a final decision where $150,000 worth of violations are still outstanding. So maybe they can do something where they, for instance, post a bond. There's probably ways of going about this, but it's not up to us to figure it out for them. Okay. Okay, what else? I think that was it. So, and I also, again, want to underscore that you cannot continue to ignore the community like this. It's just not okay. All right, so then I would, we'll schedule this for a continued hearing. We'll let you know what that date is. The community, I'm not sure exactly how, you know what, I think the best thing to do is to notify the community board when the new hearing is, and the community board can get in touch with all the people who have been interested parties, including the Standing Together group. It seems that way everyone will know when the next hearing is, okay? We will normally post it, but you won't know that we posted it unless you're paying attention, I guess. Right, Tony? Normally?
Yeah, well, what I did this time is I sent Giovanna at the community board a copy of the agenda.
Okay.
So they knew, and I think Daryl also reached out.
Okay, because at this point, I don't know exactly when it will be on for. It's possible, it's more likely that it'll be on for something like September. And I know.
So we could reach out to the community board, Daryl and I.
Okay, all right, great. I appreciate absolutely everyone calling in. I appreciate very much Mr. Pittman's really detailed presentation, which I thought was extremely helpful, and pretty soon we'll all be honorary pilots. And I thank every member of the public for calling in and being so patient. So now it is 12:44. I'm not sure how we're going to be able to do our other two hearings here, but we're going to take a 10-minute break. So back at 1, and hopefully we can, or 5 to 1, and hopefully we can finish up the others quickly. Okay. All right. Thank you, everyone.
Thank you.
Okay, are we ready?
All the commissioners in.
Everybody's here. I think we can start again.
We can start again. I apologize.
Yeah, no, that's okay. There's Jay, but he's early. No, he's not. We can let him in. And Sandeep Patel was from the prior hearing, right? We don't know. Okay.
Okay, so we're resuming the public hearing for June 16, 2020, the 10 a.m. session, 2019-165BZ, 1375 East 26th Street, Brooklyn.
Good afternoon, Jay Goldstein for the applicant.
Hi.
Hi, how are you? I think I need to be sworn in, right?
Yes.
Yes, you do. Raise your right hand, please. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to honestly respond honestly to board member questions?
I do. Good afternoon, Jay Goldstein for the applicant. We heard this morning's review session. We're pleased that the board is happy with the submission. In response to Commissioner Shetta, we've actually already made the changes he requested. We've submitted them through Submit, and we've included a cover letter that specifically details the only changes that were made to the plans. First change being on A10, we switched the existing and new. On sheet A10, we switched it to from saying left side elevation to north side elevation. On sheet A11, we switched it from right side elevation to south side elevation. On sheets A1, A3 through A7, we just added the north arrow because it wasn't there before. And on all sheets, we've updated the date to today's date.
Great.
To my understanding, there have been no other changes to the plans that the board had reviewed.
Okay. So
Thank you,
in any event, sorry, somebody else have something to say?
No, I just said thank you.
Okay. So since we never do a closed vote with the Zoom video, it's great that you did that. I'm making note. So we can put this on for decision, but meanwhile, we need to invite members of the public to speak on this item.
Okay.
So Tony, can you read the item number?
Sure, 2019-165BZ, 1375 East 26th Street, Brooklyn. If you wish to speak on that case, please call in.
Okay, so we'll give that the 35, 45 seconds worth, and we'll try to put this on for a decision. Well, first we have to close it, but we'll try to put it on for a decision sooner than later.
I appreciate it. I knew that you weren't going to be able to review it today. I just wanted one less thing on my plate.
Yeah, no, we appreciate it because I can make a note that it was already submitted and now we can review it more quickly. Okay. All right, another few seconds. There's a person named Sandeep Patel in the waiting room. That's not anybody related to this application. He's been on since this earlier today, so he may just have left his kind of Zoom off the hook. Okay. All right. Okay, then. So I would like to make, there's no one in the waiting room, no members of the public who have dialed in to speak. Okay, so I'd like to make a motion to close this one.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Okay, thank you very much.
Very much. Have a good day, everybody.
You too. Bye.
Next item is 2019-269BZ, 3425 Rumbuts Avenue, the Bronx.
Okay. We already have Leslie Snyder in the waiting inside. So when you can hear us, Ms. Snyder, please unmute yourself and speak. Thank you very much.
Good morning.
Good morning. Is anyone joining you?
Yes.
So our team has Sandeep Patel. He's the engineer for Tectonic Engineering, I believe.
He's joining. Okay.
Okay, thank you very much. We also have Michael McGuire.
Okay, he's joining.
He is our radio frequency engineer.
And is somebody named M. Sheridan part of your group?
Yes, that's my associate, Mike Sheridan. I actually
Okay.
was having some technical difficulties, so he's been kind enough.
And I note also Hillary Athrod, who represents the, what is it, the pole owner?
The sign, yes.
Okay. Okay, so those people have now joined.
Okay,
And-
so everyone's joined?
Yeah, and I,
Raise your right hand.
well, wait a second, let me just make sure everyone's already in. Yes, okay, go ahead.
Okay, so please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes.
Did the other people respond to?
Yeah, we need to hear yeses from everyone who's going to testify, please.
This is Mike McGuire. I say yes. Can you guys see me?
No.
No. We do see your name though. Oh, now we see somebody. Who's that? We have see some, oh, now we see you. Yeah, and we see Mr. Patel. Okay. And Mr. M. Sheridan. What's the first name of M. Sheridan?
Michael
Sheridan, and yes.
Okay. Okay, go ahead.
Turn off your YouTube. Somebody I think has a YouTube on. I heard some background noise.
So Ms. Snyder, if you're going to begin, please begin.
Thank you very much. First and foremost, during this difficult time, I'm glad to see that the Board of Standards and Appeals is safe and well. And I thank you for taking the time to hear this important application. My name is Leslie Snyder. I'm a partner in the law firm of Snyder and Snyder. And I'm here virtually on behalf of New York SMSA Limited Partnership, which does business as Verizon Wireless. As you recall, Verizon Wireless is proposing a wireless communication facility at 3425 Roundabouts Avenue. This property is located in the M1 zone, and we appeared before the Community Board 12 in the Bronx, and they voted in favor of the application, acknowledging that they needed wireless service, which, especially in these difficult times, the critical need for wireless service cannot be overlooked. At our last hearing, which was in March, there were 3 items that the board asked for. One was they asked that a guardrail be placed to restrict access and protect the equipment on the pole. The drawings that are prepared by Tectonic, and Sandeep Patel is here if you'd like him to walk you through the drawings, but you will see in Z2 and Z3, there is a guardrail placed on the property, and it is there to protect the equipment.
Sorry, before you go on, were you able to hear our review session earlier?
I was, and I was a bit confused because you said the guardrail wasn't on the drawings.
No, it was, the comments were that the guardrail is not dimensioned and it doesn't go all the way around the pole. And it's not shown on the site plan, it's only shown on the floor plan of the pole.
Well, it's shown on Z2, Z3.
But it should be shown on the site plan and it's not.
I guess, I don't know how you would really show it on Z1 because that's sort of our site plan.
That's the point. Show it on a site plan.
If you want that to be added onto that drawing,
yes.
I'm sure it can. This is a standard New York State DOT guardrail. It's steel, like the guardrails that you see. And again, the reason why it was placed in the location is to protect the equipment. The pole itself has been there for many years, and there's no way, even if someone hit it, nothing would happen. The only thing that would be sort of ground level with a car is our equipment that we're adding. So we put the guardrail to cover that area.
No, the reason that we wanted a guardrail was to protect the public from getting close to the equipment, not just the...
Well, the only equipment they can get close to, because the antennas are 70 over 70 feet on the ground is the equipment, the radio equipment, which is on the ground. So we've now protected them around that equipment. I don't see the need to go around the entire pole. If that was something, because our equipment is raised up, so it's not like someone can jump and touch it. But the concern the last time was that God forbid a car, because it's a parking lot, could hit it. So we protected our equipment with that guardrail. We typically use bollards for all of our sites, which are, all over, obviously.
Okay, here's the problem. The drawings are so minimal, we can't tell any of what you're saying, right? It shows this site plan, shows the pole in the middle of the lot, and it's in the middle of the lot. So as far as we're concerned, it's completely exposed to cars, it's completely exposed to the public, right? And you don't see the guardrail wrapping around it in the site plan, right?
It is shown on Z3, but
I'm talking about the site plan.
okay, but if that's
let's
necessary.
Let's just stay with Z1, all right? Because
Right.
when you have a site plan, you're supposed to show what you have on a site plan. And site plans show fencing, show landscaping, that's what they're for, okay? Then when you go, so it's in complete isolation on drawing Z2. And you don't see the guardrail because I guess it's higher up, but in elevation 1 on Z2.
It actually, Z2 does show the guardrail. It shows the pole and it shows the guardrail. It says proposed Verizon wireless guardrail to protect equipment and restrict access.
No, stop. That is in elevation, not in the site, in the plan.
I understand. You want it on the site plan. That's fine. We can.
No.
We can,
You're answering before you let me finish the sentence. Just calm down and let me tell you what we want to see, okay? Want to see the guardrail on the site plan going all the way around the pole. We want to see the guardrail shown in plan on Z1, which is, Z2, which is 2Z2 doesn't show the guardrail at all right? We see it in the elevation, 1Z2, but it doesn't tell us how high the guardrail is. And if the idea is to prevent people from touching the equipment, and it's only the height of the wheel base, then how does it prevent people from touching the equipment? It doesn't. It looks like you can, because I had no idea it was the height of the wheelbase. And so now I realize kids can climb on the wheelbase and climb on the equipment. So you're doing nothing to protect kids, basically, or people who might want to climb around on the equipment from the equipment. Then,
let
me just finish, please.
Sure.
And if you look at Z3, it's again only showing the guardrail at a distance of 6 feet away, but only on one side of the pole as opposed to the other side of the pole. And it doesn't show the guardrail closing. So it looks like the guardrail is just on the outside and then completely open to the other side because you don't see the little posts. So it looks like you can penetrate that way. So don't forget, when you think about these sites, you think about it from the point of view of Verizon. We think about it from the point of view of protection of the public. And we want to make sure that the public can't touch, access this equipment. Okay.
So let's talk about that, because actually Verizon Wireless, as well as myself, we do think about the public. So the issue that was discussed was really to make sure that no cars can hit the pole, because obviously this pole has been around. The antennas, which is what transmits, which I know you're very concerned about health effects and RF energy, and we'll get to that with Mike McGuire, but the antennas are 70 feet above the pole. So no one could, that you'd have to be a witch flying in a broomstick up to be able to touch the pole and be in the RF energy. So if you're concerned about RF energy, there's no concern because no one is 70 feet tall that can touch the antennas. The only other thing is the security for our equipment, which whether a car can hit it, we usually put either bollards, and we have, this property is also fenced. But if you like, if you want to go into more detail, Mr. Patel can explain the guardrail and his thinkings as to how he dimensioned the guardrail and placed it in that area. So if you, I'm sorry.
We know
Mr.
that
Schechter.
the antenna is high. Your elevation shows boxes of equipment low. So
Right, that's computer equipment. That doesn't transmit energy.
we're
So,
not talking about transmission of energy. We're talking about the equipment. And
right,
you-
I think the property it has a gate and a fence, but Mr. Patel,
Okay.
you're on the call. Let him, if he could explain his drawings with a little bit more detail, I think that'd be helpful.
Okay.
Yes, there is a fence around the compound and there is limited access to that area. It's not open to public.
How do we know, what do we have that tells us that it's not open to the public? When we look at what is this is an active business on this site. And the cars that are parked around it are for some kind of a business that's not related to Verizon. And as far as I can tell, there is no broader fencing around this equipment that keeps everyone away. We see these sometimes where they sit inside of a caged area and no one can get through the chain link fence caged area. That's not what we're seeing here. We're seeing something where I don't see a fence even around the site. So I don't understand the statement.
Actually, if you look at the sheet Z1, there is a fence shown around the whole property. And there is an existing chain link fence with locked gates, and you would need the owner's permission or somebody has to let you in. It's not open to public.
Sorry.
Where does it say
Z1?
there is a fence on the side plan?
It does not.
It's not called out, but if you see the line with the X's on it, that's the fence.
Yeah, but who said that? If this line could be a property line, it could be a dimensional line, it could be anything else. If it's not called, it's not there, right?
We can add the call out if that's what is required. Yes.
And what is?
Go ahead. I'm sorry.
What is the issue of adding a fence around the pole? My understanding is that you have a cabinet close to the grade, right?
Yes.
So if you have a cabinet, why wouldn't you fence that? To protect it and to protect people from like be close to such equipment. What is the issue with that?
Engineering wise, there is no issue to that. I will let Leslie deal with any leasing issues that might.
I would say engineering wise, this is favorable.
Ms. Schneider, do not interrupt.
No, I apologize. It's a little difficult, but we have no objection. If in lieu of the guardrail, you'd rather have a fence around the pole, as long as the owner has no objection, we have no objection. I think what Mr. Patel is saying is the property itself is fenced off. So we're already restricting access to the property. Then
this is not shown on the site plan. This is number one. Number two, if you look at D3, the drawing that you're referring to, I understand that it's a semi-circle fence. It's supposed to close to the tower or the pole. So it's not a full circle, it's semicircle. I might be okay with that. But if you look at the small circles, the rods or the posts for the fence, if you zoom in and look at these posts, they are not located all around. It's just scattered some way like on a quarter circle. I believe what is creating all this dilemma is the quality of the drawings that we're preparing. So come on.
I have no objection. So Commissioner Schechter, if we show the fence, that the property itself is fenced, and then if we show the guardrail with the bollards, I gather those are the bollards, I believe, Sandeep, is that correct?
Those are the posts for the guardrail, yes.
The posts for the guardrail. So if we do the guardrail in the fashion and we show that the property is fenced, is that sufficient, or do you need the guardrail to go all around?
Wait a second. So here's the thing. I'm not sure what's going on here. This is Verizon. It's not a little, pizza store that doesn't have any money. This is Verizon. Why is there so much pushback about fencing this area so that whoever it is who drives their cars into this site doesn't have access to this. Put a real fence around the entirety of the pole, 6 feet back if that's what's necessary in order to make the working around the pole work, because I assume the workers need 6 feet for whatever reason, with a fence, a chain link fence that's say 6 feet high or 4 feet high, so that 6 feet high, so that people don't go inside. And if you're concerned, you owner are concerned about cars hitting it, then you would have also this guardrail around it, but it has to go all the way around, and there's a fence, etc. That's yours. What goes on in the rest of the site with cars parked is the activity of the owner of the lot. And if they want to fence it or keep it open or allow people to drive in at will, that's their business, because we are not regulating that use. So I don't really want to hear any more discussion about this. One fence, 6 foot high, all the way around the pole at a distance of 6 foot, whatever they showed, 6 foot 6 inches from the pole, all the way around. And show it graphically the way an architect or an engineer shows things graphically, with indicators, with lines on them of proper line weight. Why are we having this discussion? It's ridiculous. All right, let's move on.
I just want to confirm with my engineer, Mr. Patel, is that feasible for us to put a fence, because now it's a fence within a fenced an area. Is that feasible to put a fence around the pole?
Yes.
Okay. We'll just have to get, obviously, the owner's approval, but we're hoping that that will be the case. I think the second item for us was the radio frequency report. So if you recall at your last meeting, you wanted to be sure that anyone standing on top of any of the buildings in the area would not exceed the FCC limits. Let's just take a step back. The FCC has issued regulations governing RF emissions from these facilities. And we are required to show in a report how we comply with those standards, which we did. What I'd like to do is, I know you had some questions about the report, and you'll see in the report that we meet all the FCC standards, whether at the pole, at ground level at the pole, 10 feet on top of any of the nearby buildings. But what I'd like to do now, if you'd like, is I do have Mike McGuire, who's a licensed professional engineer, licensed with a specialty in electrical engineering, and he can walk you through the report if you think that would be helpful, or if there's any particular questions that you have.
Well, if he heard our comments, he can respond to our comments. Go ahead. You're muted though. Okay.
Hello, everybody. I listened to the morning portion and been through this a couple times. And I have a prepared speech, but I think it's probably better if I just kind of answered your questions directly from this morning. If you look at this report that was issued in April, it's 21 pages long in PDF, if you count the pages on the PDF. And one of the concerns was that there was no colors indicating the different field levels on pages 10, 11, 12, 13, 14 of the PDF. And the reason for that is because when we're looking at, let's say, page 10 of 21, we're looking at a horizontal slice at 35 feet above ground level at the fields at that point. And they're simply, if you look at the legend on that same page, it shows from 0 to 1% as being white colored. So therefore, it's white on white, you see nothing, because there are no fields that are greater than 1% at that above ground level. And therefore, any of the other pages after that, 11, 12, and 13, are lower, and then even at the ground level, there's still no fields because they get, it's like if you think of the RF antenna as a light bulb, as a floodlight, the closer you get to it, the higher the intensity. And when we were looking at 35 feet on down, there's just nothing there. I know this is a hotly contested site, but from an engineering perspective, for the RF component of the engineering perspective, putting antennas on top of a pole not on top of a building is a very ideal situation, because there's nothing to irradiate. There's no building structures. There's nothing. If you look at page 9 of 21, what we're looking at there is a horizontal slice through the center of the antenna that actually has colors on it. And that's because we're cutting right through the antennas where all the power is coming out of. That's like slicing through the floodlight itself. And you can see that we put little colors in there to kind of differentiate the different levels that you're crossing over as you get closer and closer to the antenna. There was another.
Page 9 is not a horizontal slice, I believe. It's a vertical.
I'm sorry?
It's a vertical one. It's not a horizontal one, right?
This is
like,
a
like you're showing the profile in a vertical section. Am I correct?
Yes.
In order to show the vertical section, you have to take a horizontal slice right through the antenna. Sorry.
That's a vertical
I'm nervous. It's my first time, right? So you're right. You got me.
Don't worry. Don't worry. Don't worry.
No, that's fine. Yes. I just wanted to fix it on the record. That's all.
Mr. McGuire, I have a question though. If you could go back to the plans where it's white on white.
Page say 10 of 21, right?
10 of 21. Okay. My question goes like this. If the reason I keep asking why is it white on white is because the way that it reads now is it looks like you've actually taken measurements or done modeling or whatever all the way across the New England Thruway and all the way across even beyond the cut lines on your drawing, because everything is white on white. But in fact, what you're doing is there's some distance to which you measure. And that distance is what should be reflected in, let's just say, beige, right? And beyond the beige, is a non-measured zone, like it's outside of the scope of our review. But within beige, it's 0 to 1%. You know what I mean? Because it's weird. Even EBI consulting is in the study according to that, because it says it's white on white.
Well, the way they do it is they don't really position themselves around the ground in the surrounding environment and calculate the levels at those points. They do it from the antenna outward. And so it basically goes on for infinity when you're beyond the different color of whatever on page 9, whenever you're beyond the green area, everything everywhere with respect to this antenna is less than 1%. So they're only trying to make it easy, but somehow us engineers made it worse.
I believe what the chair is asking for is some clarity to the plans starting page 10 of 21. What we're saying is, if you look at this plan, you have two buildings, I believe, where you showed the height, 35 and 30. You're mentioning the height of two buildings.
Right.
Yes.
No, I'm sorry, 3. Actually, there is one for 25 as well. When you look at that figure, and it says ground level 0, and when you look at this plan, number 1, you're not sure at which height this plan is taken. Yes, it says for above, it says 30 feet above grade level.
That's above ground, yeah.
So these are the measurements, but the extension horizontal wise is unlimited. And if you go to even the margins of the page itself, outside the squares, it's white. If you elected another color instead of white, or even if you box a limited area around the pool and point to this and say, this is the study area. Like just for like a very simple note, this is my study area. Anything beyond that is not covered by that.
Right.
Any exceedance beyond this border might be resulting from something else other than whatever covered by the scope of this stuff. It's liability issues And we're actually, what we're asking you to do is to cover yourself, to protect yourself. Because if I have a house 10 blocks from this guy and the scale allows, and I get an issue, I have the right to come after you, to go after you, because your report covers it, but you didn't intend to do so. But this is the way you showed it.
But I'm not even talking about liability issues. I'm talking about, it's just so weird. It's like, I get like in elementary school where you get like a little diagram and you're supposed to color it in, and then according to answer some sort of mathematical question, you don't know the answer, so you hand in a blank sheet to the teacher and the teacher gives you an F, right? You just handed us a blank sheet. There's no information on it, right? That's kind of what it looks like.
Why it saves money when you print in color. Yeah.
Yeah, go ahead, Mr. McGuire.
I don't think, electronic, there's no money to be saved printing, but the point is there's nothing there, anything below 22 feet, or what is it, 10 feet below the antennas or 6 feet below the antennas.
But people understand what we're saying.
So I could color the entire globe as white, and there's no fields there.
Yes, yes.
Right.
And for me, it is clear. I'm okay with it, but can you please provide us with a plan, similar plan to one on page 10, but at the antennas level? This is like a horizontal plan going through the vertical section you showed at the top, showing the green, the blue, the yellow. I'm sure you're gonna have some probably harder spots too.
Right. Wait. I couldn't understand because you can't, on Zoom especially, you cannot speak while the other person's speaking, because then we hear neither of you. So Commissioner Sheta, please restate what it is that you want.
I need another plan similar to the one on page 10, but at the antennas level, and show on it whether we have any red or not. If we do not, that's fine. This is your study. But we need a horizontal plan at the peak, showing the extension of different intensities or numbers.
Okay, so that, and then I would like to add to that number, page 9, doesn't have any dimensions. You say ground level 0, but then I don't know how tall this pole is. I don't know at what height it starts being green and starts being blue. And I also, you'll see that in plan. I also don't know what the extent of the blue is, because there's no dimension given, and the grid says it's a 10-foot grid, but I don't know if that's actually accurate, because I mentioned about another grid that's not really representing the grid dimensions.
He could probably add a ruler next to the pool, like a vertical ruler, to show different elevations or heights. But if the grid is accurate, if what is mentioned on the grid is accurate, I believe it's 10 feet, it's 10 feet. So I could measure from the grid, that's fine.
Yeah, but we don't know if the grid is accurate because it's not accurate on another drawing. So that's the point, is the other drawings that use the little gridded paper that say it's 85 feet. For example, on drawing, what is this, 11 of 21, just to use that as an example, it says that the grid is 10 feet. And if you count the grids, it's only 50 or 60 feet. Yeah, go ahead, Mr. McGuire.
Thank you. Right, I was getting to that. I didn't quite get there in my pre-ramble, but to address that concern, it's kind of simple, really. Those grids are there as kind of a reference, as like a ruler, as Commissioner Sheta said. So if you have this is sort of like a square. I'm just kind of making an example. If this is say 10 units left and right and 10 units up and down, if you're trying to measure across that, it's more. It can be as much as 14 units across it.
Right.
To the whole distance. If you're going completely diagonal across it, corner to corner, it's only 10 left to right or up to down. So I understand how you could get 5 blocks over, but if you measured them as like a a straight portion and then tilted it at an angle, you'd find out it's really close to 85 feet. And since there's nothing beyond 22 feet that's over the level, I mean, you're looking at 0.0001% of the GP limit or 0.0001.12% of the GP limit, that type of thing. It's kind of really in the noise, small detail. So those measurements are fairly accurate, but since there's nothing beyond a small radius that shows you any emissions above 1%, it's kind of in the noise. 85 feet, 90 feet, it's all kind of less than 1%. Regarding the axis, the slice, if you will, through the antenna, that will show you the different radiating levels at the antenna level. We can provide that. That can be done. But generally, if we put it in the report, it can tend to be confusing because people would think that that's kind of that at the ground level or something. But it's something we can easily provide and share with the board if that's going to help.
Yeah, because if you're willing to show the cross sections up until 35 feet, why not the cross section at the height where you start to have radio frequency, especially if you, in response to Commissioner Sheta's question this morning that had to do with, or earlier today, that had to do with as of right building heights in the neighborhood, right? If this neighboring properties were built to what the zoning allows, is there a penetration? That's the question.
Yeah, I think with respect to that question, it's purely speculative. To be frank with you, if there was a building that's built taller than this building, we would take our antennas off because we would have an interference problem. So it's kind of irrelevant. The thing that you asked at the last meeting was, tell me a worker or anyone standing on the roof of all the neighboring buildings in the area if they could possibly exceed the RF emissions. We've established that. This report actually establishes that unless you're 22 feet from the antennas and 68 feet in the air, which is impossible, unless you're a witch flying on a broom, like the Wizard of Oz, you cannot exceed the RF emissions. What's going off the page, and one of the commissioners says, what about 10 blocks away? 10 blocks away, they're gonna meet the FCC standards. That's why the FCC has specific regulations. So if you feel you need additional information, please detail it, but this is beyond what the FCC requires. They're the governing body. We've showed we've met the standards. We've showed it's actually impossible, even if on these neighboring roofs, to exceed the standards. So I'm myself unclear of exactly what else you feel you need to be sure. And it should be stated for the record that the community board is in favor of this. Not one resident has spoken against the application. This is a need. This is a need for a service. That's a public utility that I can't imply upon you more how critical it is. And every day that our service is not as reliable as it should be is a day that someone can be in jeopardy. So anything we can do that can move this along and get our approval would be greatly appreciated, because we believe this site meets all the criteria.
So I never heard this before. If a building is built to what height you would take your antennas down?
If a building is built so that we could not get above, let's say a building was built on the adjacent property and it was taller than the height of this pole, there's a chance that we could be blocked in our signal, because obviously it's line of sight technology. So we would have, if we have an interference problem, the site would be no good. We'd have to remove our antennas.
But if it were not taller, go ahead, I'm sorry.
I'm sorry, Chair. But our concern here as a board is not your antenna get blocked. Our concern here is to make sure that every single building around this antenna, whether it's existing now or it is tolerated by the current zoning, is protected. This is my goal as a member of this board.
I understand.
Please let me finish. And what we did ask for last time was very clear. We did ask for a check that if there is somebody who's standing on a roof on an adjacent building, he's not going to be hit with something that exceeds the FCC limit. We didn't say whether it's the building is existing or it's future building tolerated by the zoning. If you simply can, I believe it is simple to run this kind of a check. If you mention that 22 feet away, there is no exceedance, then there is no exceedance. You could check the tallest building possible per current zoning, and you could just put a statement in the report and you're done. I'm not sure why this is difficult. And you're kind of like indicating that we're trying to delay this and everybody's gonna be in jeopardy. I don't understand.
And I just want to add, this isn't, I'm a little confused by your level of pushback. It's very surprising in light of the rather innocuous questions we're asking, I have to say, with respect to this aspect. This is an M11 zoning district where 1 FAR is the maximum. And that means a 1-story building in a commercial district, which is typical of this area. And if anything, maybe you figure out how you get a 2-story building. And there's a height limit. I think it's a 35-foot height limit. Isn't that correct? No, what's the height limit? It's a 1-to-1.
It's basically it's 30 stories, 30 foot is the street wall height, and then there's a 1-to-1 sky exposure plane.
So this is super easy to do, and your pushback it just is, I think, is inappropriate in this situation. Super easy to do. What?
Well, it's a statement in the report. It's
a statement in the report with a little bit of study. Okay, but I think you have a much bigger problem than this, and that has to do with the legality of the poll. And to put it all on us, it's not our job to find Verizon sites, right? So the legality of the poll, which is what DOB commented on to us, more than commented, gave us direction. We don't have the authority to waive the bulk regulations here. Your pole is tall. It's taller. It apparently penetrates the sky exposure plane. So and the reason we were having this discussion about radio frequency is we figured, well, you could lower the pole, or maybe the property owner would be willing to have you relocate the pole so that it clears the height and setback requirements, because right now it sits very close to the property line and as a result does not fall behind the setback requirements. So maybe there's a way for you to relocate it or something, making a deal with the property owner. But we don't have the authority, as we said earlier at an earlier hearing, to waive the bulk regulations, and we don't see so far that DOB has grandparented or vested the right to have this pole. That's the most critical part here.
Well, at this point, I'll have Hillary, who has given you much documentation on this, but Hillary, why don't you discuss, because I know we've discussed this before, but why don't we discuss again the legality of the poll?
Okay, and Ms. Azra, obviously identifiers.
Hi, good afternoon, everyone. Hillary Atzrat for Outfront Media. Outfront Media previously had the sign that was located on this property, and they're the owner of the monopole structure. So to provide some additional color, I listened to the executive session this morning, and I heard some of the comments out of the DOB regarding this sign. And I also had spoken to the sign enforcement unit. I was also involved in this document previously that we're referencing. And the BSA has actually dealt with some applications that were related to this agreement that Outfront entered into with DOB several years ago, relating to the legalization of signs or the conversion or the removal. And so I completely agree with DOB's classification that one of the goals of this agreement was to toll the enforcement provisions. That was one of the goals. But the reason that these particular signs were included in this agreement, and I outlined this in my February submission, is that they were signs that were either pre-1961 or they were signs that were initially constructed as accessory business signs and at some later point converted to an illegal advertising use. But with this particular sign in 1998, it was legally constructed and had all permits to be legally constructed. In order to be in compliance with this agreement that Outfront entered into with DOB, the sign panels and the head of the sign were removed, which is what leaves the monopole structure today that was initially built in 1999, legally non-complying, and should be converted, should be able to convert to a conforming use for this district. We've actually reduced the degree of supposed non-compliance by removing the head of the sign. And now we are left with just this monopole structure that is legally non-complying. Now, I understand that DOB has stated to the contrary and disagrees with that. So I want that on the record because we truly believe that that is the correct position here and that that is accurate for this sign, and the monopole is legal as constructed. But we also set forth another proposition in our February submission. And that's that, assuming for the sake of argument that we do need to comply with the sky exposure plane, we should be permitted to proceed with this monopole as it stands, because under the zoning resolution bulk requirements for M11 manufacturing districts, aerials are permitted obstructions. And by definition in the Merriam-Webster dictionary, aerials include antennas. And so the antennas proceed into the sky exposure plane, which are part of the monopole. They're mounted to the monopole, but that is a permitted obstruction in the M11 zoning district. And I'd like to turn the board's attention to BSA calendar number 18107BZ. It was annexed as Exhibit F to our February submission. And in that BSA application, there was an M11 zoning district. There was a monopole that was 50 feet in height that was being extended to 70 feet in height. DOB wrote an objection for it penetrating the sky exposure plane and due to the use requiring a special permit. And the BSA granted that application without any additional waivers. It was all under the 7330 special permit, despite the penetration into the sky exposure plane. So there's clear precedent from 2007 saying that this circumstance is permitted.
Okay, so let's, so here's this thing, is if the BSA in the past may have mistaken its authority and waived a bulk regulation, not realizing it wasn't supposed to, then we can't rely on an error. The BSA has made errors in the past, unfortunately. We've seen them, and you can't rely on an error, right? But if you disagree with DOB's interpretation about all of these various things in the consent decree and so on, then I would just have to say it's not we're not the ones who are making the determination. We actually asked you to go to DOB and get a letter or a ZRD1. And you, instead of doing it, you argued it in your papers. I appreciate that you argued it in your papers, but our instruction was go to DOB and get them to settle the controversy, right? Because we're not going to do that. And instead, we had to go to DOB, and our deputy counsel spoke several times to their sign enforcement unit. And even as recently as, I think, Thursday, and they reiterated exactly what they had told us 2 months ago. So it's not like the story changed as we went, that as far as they were concerned, the consent decree was really a tolling on enforcement, and that the way that it could be cured, that these poles could be cured, was to say, put up an accessory business sign, maybe go to the BSA, because the BSA is always viewed as a solution for everything. But it doesn't mean that the BSA can solve everything. And so really, if you want to address this situation, we need DOB to agree with you. And we're not going to rely on a situation where the BSA improperly granted something, not realizing that it didn't have the authority to do that. We can't.
So Chair Perlmutter, I understand that, and I'm happy to go and speak directly to DOB. Again, I have spoken with them previously with the sign enforcement unit, and they basically told me that they didn't object to this application and were deferring to the BSA. So I'll reach out to the project manager at BSA, and I'm happy to get the actual correspondence, so I know exactly what that dialogue was between BSA and DOB. But I cite to this one M11 case, 18107BZ, understanding that mistakes might have happened in the past. It doesn't seem from the history of this case it was a mistake. There's clear whereas clauses and a lot of different points were discussed in it. We also attached a chart outlining, I believe, close to 40 cases where 7330 was the special permit at issue. Several others also dealt with the same sky exposure plane issue. So this doesn't seem like it was a one-off occurrence, but rather a consistent policy and a consistent decision that was made in granting these special permits. And so, you know, on that basis, we continue to maintain that in this DOB objection that we received to come and make an application this time, the sky exposure plane was not listed as an objection. It was only the use that was the objection. And that this would be a permitted obstruction, and there's BSA precedent, not just the case I cited, but others as well, that would support that proposition. So
that's fair. And if DOB thinks it's a permitted obstruction, then there's nothing to dispute, right? Unless it becomes an interpretive appeal about whether an antenna or whether this is an antenna and whether this is a permitted obstruction under that, right? So I would say we have to defer to DOB in all of these situations. And I'd suggest from a business point of view that Verizon talk to your client and see whether they might just simply relocate the pole to the center of the lot, in which case it might actually clear the sky exposure plane and then you don't have this problem. Potentially. I don't know, because I don't know what the zoning is allowing. Okay.
I just think, you know, just as a policy, and I'm sure you're aware, you know, the FCC has made a policy that they want us to co-locate on existing structures. So, and, you know, I know you were concerned that we were giving pushback about the RF report. These are all requirements, you know, of the FCC, which is the overriding jurisdiction. So we've been trying to comply with your additional requirements, but I just want to make it clear they're above than what's required by the FCC regulations.
When you say overriding, I think that might be overreaching. The FCC does not, because of, you know, sovereignty issues, the FCC doesn't override zoning in the city of New York. And if this does violate the sky exposure plane, then the FCC, nothing in the FCC says that this has to be permitted. So I think we should all just take a step back. I think you've heard the statements of the chair, and I think it's best if we just address that as opposed to continuing this needlessly aggressive argument.
You know, I think, you know, we will revise our plans, the site plan, with the items that you want. We'll give the additional detail regarding the RF report, and Hillary will obviously we'll get the letter from the DOB. But we really we don't want to keep on, you know, being delayed. We really are trying to be receptive to what the board is asking. So if there is anything else that you do want before the next meeting, I would just ask if someone would be kind enough to reach out so that we don't get delayed another month or another few months, because this is something that everyone needs. It's vital. And we would really respectfully request that we do anything we can to get an approval, I'm hoping, at the next meeting. And I really appreciate your time and your patience.
Okay. We need to make the findings. This is a zoning board, not an FCC board. So we need to make the findings, and we need to have the authority to make the findings that we make. So that's what we're talking about here. We're just talking about zoning, okay? So anyway, the things that we ask for at the hearing are what we ask for. And to the extent that they're not clear, that kind of clarity can be provided by the project manager. So who I believe is that Jolene? Who's our project manager on this?
Yes, it's Jolene.
It's Jolene, okay. So if there's something you didn't understand about what we said today, please reach out to Ms. Ebanks Chu. And otherwise, please provide them information that was requested, and Ms. Azrat will need to go to DOB to either to have them agree on one version of her argument in order for us to be able to proceed with this. And we don't control that kind of time at the Department of Buildings. So, okay, so now I'd like to ask if there are any members of the public who would like to speak on this application. Tony, can you read the application number and address? Tony. Lost Tony. Okay, I will read it if I can get to it. So this is application number, oops, wrong. Sorry. Application number 2019-269BZ, 3425 Rombouts Avenue in the Bronx. If you're interested in speaking on this application, please dial in to 646-558-8656. Meeting ID number 997-4505-1680. We'll give it a few minutes because there's a time delay on Zoom. Okay. Okay, so we will give you enough time to work with DOB and to return, and we'll let you know when the next hearing is. We don't assign the hearing dates on the Zoom call. Okay, but we'll let you know by the end of the week when we reassign this too. Okay, thank you very much, everyone.
Thank you very much.
Okay, this concludes the public hearing for June 16, 10 a.m. session. We resume it.
I don't know what to say. So I think that because it's a 2 p.m. hearing, we should at least announce it and then take a, what do we have next? Sorry.
We have, you want me to announce the cases?
Yeah, what we could do.
I would note that we're not in the Zoom meeting.
Yeah, that's what I'm gonna say.
Yeah, so let's come back at 2 and we'll announce the cases, and then maybe we'll have like a, I don't know, commissioners, what do we need? A 20-minute break? Is that enough? 20-minute break right after we announce the cases, okay?
Okay, so let's, can't leave? We have to leave.
Yeah, we have to leave. Okay.
Okay.
Thank you, Kurt. Also, thanks, Tony.